Well, good morning, and welcome to the McGuireWoods New Developments in Tax and Wealth Planning Seminar. For those of you who don't know me, my name is Ben Canlin. I'm a partner here in the Private Wealth Services Group at McGuireWoods. We've been doing this seminar here in Richmond for over 10 years now, usually in person. Last year, of course, was virtual. We had hoped to be in person again this year, but it wasn't meant to be. So hopefully next year. But we're grateful that we have the technology to still connect with you virtually. Please note that during today's program, you should see a button that would allow you to ask questions. So it's not quite as easy as if you were here and you could just raise your hand. But if you do have a question, feel free to press the button and we'll do our best to get to your question. Now, we recognize that we have over 230 people registered for this seminar, and we have a fairly diverse group of people in that we have accountants, we have investment folks, we have bank trust department people, we have insurance people, we have lawyers. So we've tried to select some topics that will give a little something for everybody. But we're going to start things off today by talking about some of the statutory updates and case law updates with a particular emphasis on Virginia. And of course, we're going to talk for a few minutes at least about what may end up being the biggest story of the year, and that is the potential changes to the federal, state, and gift tax laws. So we'll begin with Abby Farnsworth, who will discuss the statutory changes, and then I'll come back and talk about the recent updates in court cases.
All right. Good morning, everyone, and thank you all for joining us today virtually. And let me be the first to wish you a happy National Estate Planning Week. I learned that this morning while I was reading the news, so perfect timing for our seminar. As Ben said, we're going to cover a couple of the legislative and statutory updates that we've been learning about both at the federal level and some of the Virginia things that happened this year. So first, I just want to start off with a quick overview of our current tax rates and exemptions. I'm sure everyone is well aware. So just a quick overview, the top rate right now on ordinary income is 37%. Of course, we have estates and trusts subject to that top rate with the $12,500 in taxable income. The top rate on long-term capital gains and dividends is at 20%. For taxpayers in that highest bracket for income tax purposes. We have the very high state gift and GST tax exemption of $11.7 million per person, or $23.4 million for a married couple, and the gift tax annual exclusion at $15,000 this year per donee. Since the start of the Congress in January this year, there have been numerous changes proposed or raised for discussion in both the House and the Senate. The changes that have been proposed and talked about generally fall into four categories. Of course, when all is said and done, we won't see all of these categories met with the changes, but this is the general things that have been discussed. A reduction in the exemption and increases in the estate and gift tax rates, possibly imposing a capital gains tax on the transfer of assets at death or during the life of an individual, some form of annual tax on the wealth of high net worth taxpayers, and the possible repeal of one or more of the estate tax, gift tax, or GST tax. Or a possible reduction in the top rate of tax on those in those categories. Again, these are just the proposals that have come up and come and gone in the year so far since the beginning of Congress. The legislative changes that are currently proposed and being considered in the House would result in a huge paradigm shift for the estate planning world. Many of the tools that have been the central focus of estate planning and transfer planning for decades will no longer be feasible and will no longer work if these particular proposals become law, as we've seen them so far. If we start from the beginning, just during Biden's campaign, he had some significant changes that he highlighted and that he intended to push for as president in terms of taxes. The highlights of those, he suggested increasing the top income tax rate for taxable income above $400,000 from 37% to 39.6%. Taxing long-term capital gains and qualified dividends at the ordinary income tax rate of 39.6% for income above $1 million. He suggested eliminating the step up in basis at death for capital gains taxation and taxing the appreciation at transfers, which would effectively create a capital gains tax at death and possibly when appreciated assets are gifted during life. He discussed restoring the estate and gift tax rates and exemptions to 2009 levels. That would basically mean a fixed $3.5 million estate and GST exemption, a fixed $1 million gift tax exemption, and a top rate of 45% on amounts of over $1.5 million. And lastly, he discussed changes in the corporate tax rate from 21% to 28%. So he had a lot of ideas during his campaign, and some of those are being incorporated into the proposals that we're seeing now. We've seen several proposals come through in the last few months. We had Senator Sanders introduce the 99.5% Act in March of this year, which was very similar in a lot of respects and at times identical to his for the 99.8% Act, which he introduced in 2019. A couple of the highlights of those were acts that he introduced were reducing the basic exclusion amount to $3.5 million, not indexed for inflation for estate tax purposes, and $1 million, again, not indexed for inflation for gift tax purposes. And a general increase in the rates of estate and gift tax. A couple of other highlights of his bill were making major changes again to the transfer tax system, including extending the basis consistency provisions, increasing the estate tax deduction for conservation easements, valuing entities by treating non-business assets and passive assets as owned directly by the owners, and eliminating valuation discounts, minority discounts, and lack of marketability discounts for any entities in which the transferor, the transferee, and members of their families had control. He also, that bill also included, or his proposal also included a lot of major changes to grantor trusts, which were incorporated into the proposed legislation that we received on September 15th from the Ways and Means Committee. They referred to this proposal as the Build Back Better Act. And I will try to say that a few times without messing it up. But this new bill includes a lot of provisions that will drastically change the way that estate planners deal with the transfer of wealth from generation to generation. The first major change that this bill presents is the early sunset of the 2017 Tax Act's doubling of the basic exclusion amount. So that sunset will be accelerated if this bill passes from January 1, 2026 to January 1 of 2022. It will return to $5 million, indexed for inflation, which will be approximately $6 million in 2022, a little bit more than that. So that's the first major change that this proposed legislation will put in place if it's passed. The second change, and the change with possibly the widest impact on the estate planning world, is the changes to grantor trusts. The bill from the House Ways and Means Committee creates a new Chapter 16, which consists solely of Section 2901. And what Section 2901 does is it operates to effectively link the grantor trust rules with the transfer tax rules so that a grantor trust will continue to be subject to gift and estate tax consequences after it's created and after it's funded. As I mentioned, this bill includes the proposals of Sanders for the 99.5% Act, but with some significant changes as well. As to a trust or any portion of a trust that is not otherwise includable in the grantor's gross estate, and that is funded after the date of enactment. This new section 2901 provides that the value of the gross estate includes the value of all of the assets of any portion of a grantor trust, which the decedent is the deemed owner at the time of death. The section also provides that any distribution during the lifetime of this quote-unquote deemed owner from the portion of the trust that he or she is treated as owning for income tax purposes will be treated as a gift and subject to gift tax. A couple exceptions to that will be any distributions to the grantor himself or herself, to the grantor's spouse, or in the discharge of any obligation of the grantor. So a couple of carve-outs there, but in general, distributions from a grantor trust will be treated as gifts and subject to gift tax. If the portion of a trust ceases to be a grantor trust during the lifetime of the deemed owner, the portion of the trust, that portion of the trust will be treated as a gift also, subject to gift tax at that time. Now, the new section does provide for adjustments that may be made to the amounts that would be included in the gross estate of the grantor or treated as transferred by gift to account for any amounts that were previously treated as taxable gifts. So there won't be a double taxation situation. Section 2901 will not apply to a trust that's otherwise includable in the grantor's estate and part of the deemed owner's gross estate without regard to Section 2901. So if it's already included in the grantor's estate for some other purpose, then Section 2901 will not be applicable to it. The other major change that we see for grantor trusts in this proposed bill concerns sales between a grantor and a grantor trust. So as many of you know, for income tax purposes, a grantor trust is essentially treated as the alter ego of the grantor for income tax purposes. And any income and deductions attributable to the assets of the trust are just reported on the grantor's tax return. The bill would add a new section that would provide as follows. In the case of any transfer of property between a trust and a person who is the deemed owner of the trust, such treatment of the person as the owner of the trust will be disregarded in determining whether the transfer is a sale or exchange for purposes of this chapter. Because of how grantor trusts are currently taxed, when a grantor sells appreciated assets to a grantor trust, no capital gain is triggered. Any interest in any interest payments on any associated promissory note with that sale are also income tax free to the grantor. The proposed legislation basically takes this away. We use this very frequently, so this will be a major change for estate planners everywhere to deal with. So because of this bill, the gain would be recognized by the deemed owner or by the trust, or possibly both, depending on the circumstances of the sale. It does appear in the bill that the treatment of interest on loans between a grantor and a grantor trust would continue to be income tax free, but that is not 100% possible, for sure. Again, this section would not apply to fully revocable trusts. So if that's the case, we can still have the transfer of assets without any recognition of gain. Related to the sales situation between a grantor and a grantor trust, the bill also amends Section 267, which generally disallows the recognition of losses on sales or exchanges between related persons. And the way the bill is amended to affect grantor trust is that a grantor trust is added to the list of who is considered related persons by 2067 Section B. And this effectively disallows the recognition of loss on the transfer of property to a grantor trust. So another big change affecting a major planning tool. Now, the effective date of this, these new provisions will apply to any grantor trust that is created after the date of enactment, and to any portion of a trust established before the date of enactment, which is attributable to any contributions made after. So if you have a grantor trust that's established already, it's already funded, in theory, that trust would not be subject to this section. But if any future contributions are made after the date of enactment to this trust, you will be having a split trust situation where part of that trust would be subject to these new provisions and be treated differently than the quote unquote grandfathered part of the portion of the trust. There is also a rumor that the proposals may apply to grantor trusts which have been created or transactions occurring or additions to a grantor trust after the date of introduction of the bill, which effectively was September 12th of this year. So what does this mean for us? Just a quick summary, the assets of a grantor trust created after the date of enactment or possibly after the date of introduction are includable in the grantor's gross estate. The value of the assets added to a grantor trust created after the date of enactment are also includable in the grantor's gross estate. And gain, but not loss, will potentially be recognized on the transfer of appreciated assets to or from a grantor trust, other than perhaps initial funding by gift. So these represent some major changes and effectively eliminate a planning tool that has been used for a long time in the estate planning world and will require us to become a little bit more creative in our planning strategies. Some potential adverse consequences for GRATs, SLATs, QPERTs, grantor charitable lead trusts, grantor charitable remainder trusts, possibly some ILITs, many of the wealth planning tools that estate planners use regularly. Another major change proposed in the bill is relates to valuation of certain non-business assets in entities. So a common estate planning strategy is to transfer non-publicly traded or other hard-to-value assets and have those assets valued at the lowest defensible value. This will still be doable with interest in operating businesses, but not family entities that are funded with marketable securities or something similar. The bill would require valuation of non-business assets in an entity by a look-through method. So this new section 2031 D1 would read as follows. In the case of the transfer of any interest in an entity other than an interest which is actively traded, the value of any non-business asset held by the entity with respect to such interest shall be determined as if the transferor had transferred such assets directly to the transferee, and no valuation discount shall be allowed with respect to such non-business assets. And such non-business assets shall not be taken into account in determining the value of the interest in the entity. So this is a huge change. This proposal is estimated to raise $20 billion over 10 years. Unlike for the 99.5% Act, this bill does not include the general prohibition on minority discounts in family-owned or controlled businesses. So maybe one positive there. A couple other portions of this bill include, just a quick overview of these, the increased benefit for special use valuation from $750,000, which has been indexed for 2021 to about 1.2 million to 11.7 million. It has proposals for increased individual income tax rates. The top rate to be 39.6% for taxable income over 400,000, with an additional 3% surtax to be applied to the quote unquote modified adjusted gross income over 5 million for individuals, and over 100,000 for trusts and estates. So again, we see trusts and estates being subject to this tax at a much lower income level than individuals. The bill includes provisions for the increased capital gains rates from 20% to 25% for taxpayers in the highest income tax bracket. It also includes adjustments to other corporate income tax rates and limitations on qualified business income deductions. I'm not going to go into details on all of those changes, just wanted to focus on the things that are going to have the widest impact on estate planning and the things we do every day for our clients. So that's a quick overview of the federal changes. I want to talk about a couple of Virginia proposed bills that we've seen come through, and some that have been deferred and not necessarily passed yet, but that may be particularly relevant to estate planning in the future. The first is the recordation of electronic documents and electronic notarization. Although the Virginia General Assembly didn't adopt the proposed bill that would have authorized electronic wills and that would have clarified, the use of remote witnessing and remote notarization for other estate planning documents, House Bill 2064 did address some other issues regarding notarization and recordation of electronic documents generally. Hopefully they will, they may reconsider the electronic notarization of wills and other estate planning documents in the future, but right now that is not something that passed. A couple of other states have authorized that, so we'll see how that goes. But the bill that did pass provides that clerks must now accept for recordation any electronic filings under the Uniform Real Property Electronic Recording Act, so long as they have the e-recording system in place, or they have to accept a copy if they don't have that in place. As to electronically notarized documents, if it appears to be properly notarized, the clerk must accept it. They no longer have the discretion to decide whether to accept or reject these documents like they did in the past. The legislation also expands the means by which an e-notary may confirm the identity of a person whose signature is being notarized. So the notary now can confirm identity through personal knowledge, something we're very familiar with, a prior in-person identity proofing process, a valid digital certificate, which is accessed by biometric data or similar means, and they may also confirm identity now by the oath or affirmation of a credible witness. Again, the other portions of the bill concerning electronic wills and remote witnessing and notarization were quote unquote passed by indefinitely and may be considered at a later time. That portion of the bill was modeled after the Uniform Electronic Wills Act, which has been enacted in 4 states, and again, introduced in Virginia and in Idaho. So not very common yet, but maybe something we see in the future. That act, if enacted, would permit execution of electronic wills and allow probate courts to give electronic wills legal effect. Under the act, a will can be created, signed, transferred, and recorded in electronic form, but it would still require that the testator's signature be executed in accordance with the state statutes requiring a witness and or a notary contemporaneously. The other section I want to talk about is a section that discusses a supported decision-making agreement. Again, this has not been passed yet in Virginia, but it is something that we will likely see in the future pass. And it's what it provides is it allows an individual, a disabled individual, somebody with an intellectual or physical disability, to enter into an agreement with a third party to allow that third person to support the individual in making decisions. This agreement can cover a wide range of matters. It can address, assistance with financial matters, assistance with estate planning, assistance with daily life activities, assistance with many of the regular things that you might see an agent under a power of attorney be able to do, but with a little less authority. So a supported decision-making agreement would be what is used. And I haven't seen an example of one of these yet. This has been enacted, similar law, in about 9 other states, including DC apparently. But it's just not clear what the power or how the power of the supported decision, the supporter for the supported person, would be applicable in the financial world and how that would work. Some of the examples of the support that might be addressed include, again, helping the disabled person monitor and manage his medical, financial, and other affairs, assisting the disabled person in accessing, obtaining, and understanding information relevant to decisions regarding his or her affairs. Assisting the disabled person in understanding information and options, and things of the similar thing. Importantly, the bill requires that the Department of Behavioral Health and Developmental Services establish protocols for preventing, identifying, and addressing abuse and exploitation of any disabled person who enters into one of these support agreements. Like a power of attorney, the agreement may include some indemnification for third parties, such as financial institutions that might be relying on this agreement. Interestingly, the bill also directs the court and the guardian ad litem in any guardianship or conservatorship proceeding to consider whether a supported decision-making agreement would be a viable alternative in that situation. So this is something that we're likely to see develop in the future as an alternative. And the goal behind it is really to kind of give some decision-making back to these individuals rather than just having a third party make these decisions without their input. It's a fairly new concept, and it really shifts the substitute decision maker, such as a guardian, gives the increased autonomy and consideration of the disabled individual's own values and preferences. Again, I don't think it's a very well developed situation yet, but it's something we're likely to see in the future, and maybe something that we are, as estate planners drafting, and as trust officers and CPAs and other financial individuals having to determine whether you can follow directions of a support person in one of these agreements. Another thing that passed kind of as a result of COVID, and that continues to be in effect, is a designated support person for the disabled. Again, this is different than a support agreement for a disabled person. What House Bill 2162 did was it required certain healthcare facilities to allow disabled individuals that require assistance as a result of their disability to have a designated support person while they're admitted to this facility. That person's role is to kind of support and assist the disabled individual with their activities of daily living, communication, and also decision making. And again, this designation, the bill allows this designation to be made either orally or in writing by the disabled person or by his or her guardian, authorized representative, or care provider. Again, I think this was largely a result of the pandemic and needing certain individuals to have that support even while in a facility. So those are the highlights of our legislative updates, both in Virginia and at the federal level. And I'm sure that we will be having some more updates in the next few months and a lot of changes. I'm going to hand it over to Ben now for some case updates.
Thank you, Abby. And I don't know that we could really overstate how big of a deal this change in the estate and gift tax law would be if and when it's passed. It's a game changer. While I was sitting there listening to Abby, one of my partners sent me an article from Bloomberg that came out today, and it was entitled "The Hidden Ways the Ultra-Rich Pass Wealth to Their Heirs." Now, nothing in that article struck me as anything that's been hidden. It talks about Grantor Trust, talks about Gratz, things we've been doing for decades, and things I remember giving presentations about at the University of Richmond 10 or 15 years ago. So I don't think anything in the article was hidden, but it does call attention to the fact that this new law really does target the most effective things that we have done as estate planners for the very wealthy. So if you have clients out there that are still sitting on the fence, now's the time to act for sure. So let's talk about the cases. The reason it's so important to talk about the court cases is because the court cases are where the laws that Abby talked about actually get applied to real world situations. So this is where the rubber sort of meets the road. And hopefully by reviewing these cases, we're able to learn from them, hopefully avoid the mistakes that the people involved in those cases made, and help keep ourselves and our clients out of trouble. So the first case I want to talk about is the Hunter v. Hunter case. And this is a local case, local to Richmond, that went all the way to the Supreme Court of Virginia. Now, if you've been around long enough, you've probably come across a provision in a will or trust that might have been titled as a no contest clause. Now, these are things that are often tucked away in the back of a document somewhere in an obscure place. And essentially what they do is the provisions usually prescribe some sort of penalty for anyone who dares to challenge the validity of a will or a trust. It's basically a threat. And the threat is that if you do challenge it, the penalty may be that your beneficial interest gets reduced or maybe even eliminated. Now, personally, as an estate planner, I don't like those provisions. I don't think they're a good idea. I think there's been just a few times over the many years I've been practicing that I've actually included one of those in a document. But as a general rule, I try to talk clients out of it. But in the Hunter v. Hunter case, you had a sister named Eleanor, who was the trustee for her brother Chip. So right away, you can guess that there may be some friction. Anytime you have one sibling serving as trustee for another sibling, it's sort of a recipe for disaster in some cases. So she's serving as trustee, and Chip, the beneficiary, wanted some information from her. Specifically, Chip wanted to know why and how the value of the trust assets apparently went from $4.2 million to just $1.7 million in the space of about 6 years. Now, during that 6-year period, the market as a whole had done very, very well. So Chip was very concerned as to what caused the devaluation of the trust assets. If I were a beneficiary, I think I'd want those answers as well. So he made that request to Eleanor as trustee, and Eleanor's response was twofold. First, the trust document specifically waives my duty to inform and report to beneficiaries. Second, there's a no contest clause. So Chip, if you challenge me on this, you're going to lose your status as a beneficiary of this trust. Now, again, as an aside, you wonder, why was this trust ever drafted? Why was this one sibling put in charge of another sibling? Why was the trustee's duty to inform and report apparently waived? Why was a provision, a no contest provision, included in a document like this that would prevent Chip as beneficiary from exercising his rights and protecting himself? It doesn't make a whole lot of sense to us as outsiders looking in. Perhaps it would have been different if we were in the room with the testator at the time it was drafted. I don't know. But be that as it may, that's what the document said. So what should Chip do? On one hand, if he did file something, the concern would be that he loses his status. But on the other hand, could he really sit by and do nothing and watch as the value of the trust assets mysteriously go down in value each year? So the first thing he did was he hired an attorney, and that attorney filed a petition with the court. And what the petition did, which was very smart, I think, is it bifurcated the issues. Basically what it said is, first, judge, we want you to construe and interpret the no contest clause and decide whether, if the second part of our petition, which is challenging the actions of the trustee, would trigger the no contest clause. So if the court decides that yes, challenging the trustee would trigger it, we're not challenging the actions of the trustee. I think that was a good way to plead. Eleanor responded by saying, no, just by asking the court to interpret the clause was enough to trigger the no contest clause. So the trial court, surprisingly to me, agreed with Eleanor and said, you shouldn't have filed that petition, Chip. You're out of luck. So Chip appealed, not surprisingly. And the Supreme Court of Virginia took the case, and the Supreme Court of Virginia began its opinion by talking about the long history of no contest clauses. And it's pretty interesting. I want to read just a portion of it to you. The court explained that, quote, over the centuries, individuals contemplating death have said various things in their wills designed to strike terror in the hearts of anyone who would seek to undermine their testamentary intent. In ancient times, the terror was quite real, as the person contesting it could be cast out of the family and lose their protection. A Mesopotamian will from the 13th century BC declared that The disgruntled beneficiary must, quote, set his cloak upon the door bolt and then depart into the street, unquote. So the Supreme Court recognized that these things, these no contest clauses, do have a long history, and they have a long history of being respected and upheld by the court. And the Supreme Court of Virginia wasn't about to change that. They indicated that these provisions would be strictly enforced, even when it seems harsh or unfair to do so. But remember, this case was different because what Chip did was he bifurcated the issues. The first count in his pleading was just asking the court, does this no contest clause apply to what my second count says, which is challenging the actions of the trustee? And the Supreme Court of Virginia said, yes, that's permissible because there's a difference between construing a will and asking the court to interpret a will than there is challenging a will. There's that distinction, and the court recognized it. So the court overturned the ruling of the trial court and sent it back. So the takeaways from this case. I think the biggest takeaway is that the Supreme Court of Virginia has now given us a roadmap. It's given its seal of approval to this type of pleading, the bifurcating of the issues. And it's told us that if we're just asking the court to construe a clause, that won't be enough to trigger the clause. But I think there's a second takeaway, and I alluded to this earlier. No contest clauses are not generally a good idea. In what world do we want a beneficiary who sees the assets go from 4.2 million to 1.7 million not have the ability to even find out what's going on and why that happened? So I think this is one of those situations where that's where we all come in as advisors. This is what our clients pay us for, is to give them good advice, good counsel. And I think a client who wants to include provisions like this would be best served if we talk them out of it. So let's talk about another case, another Supreme Court of Virginia case. It's the Wilburn v. Mangano case. Now, for those of us in our world, the term fair market value means something. It's a term of art. We know that the term fair market value has been interpreted many times. It's defined under federal law. It's defined in the federal regulations. The IRS has defined it. The U.S. tax courts have defined it multiple times. Fair market value is that value at which an asset will change hands between a hypothetical willing buyer and a willing seller, neither of whom are under any compulsion to buy or sell. It seems clear. And in every gift tax return, every estate tax return, that's the value, that's the standard that gets applied. So with that background, let's talk about this case. Mrs. Mangano executed a will in which she left her home to her 3 daughters. Now, she gave her one son the option to purchase the home from the 3 daughters, and he just had to exercise that option within 1 year of probate. Now, in the original version of her will, it said that if Anthony exercised this option to purchase, the purchase price would be the tax-assessed value of the property in the year prior to her death. Now, as we all know, generally speaking in Virginia, tax-assessed value is usually going to be lower than what you could actually sell the property for. So perhaps recognizing that, she executed a codicil to her will, and she changed that provision. So instead of the purchase price being the tax-assessed value, it was changed to the fair market value at the date of her death. So she dies. Anthony exercises his option to purchase by sending a letter to his sisters. Now, obviously, if you're Anthony, you like the will better than the codicil. You like the provision that said tax assessed better than the provision that said fair market value. So he challenged the validity of the codicil. And the way he worded his option was basically, I'm going to exercise my option under the will or the codicil, whichever one is ultimately determined to be valid. The sisters responded by filing their own suit and sought to compel Anthony to follow through on his option to purchase under the codicil at fair market value. And they even went and got an appraisal. And the appraiser, 2 appraisals. The 2 appraisals, which were done under the fair market value standard, valued the property at $270,000 in one of them and $311,000 in the other. Again, Anthony, not wanting to pay that, preferring to pay the tax assessed value, sought to argue that the option was not enforceable because the will did not provide a specific method for determining the purchase price. So in other words, just saying fair market value at the time of death was not specific enough. Now, we all see that language. It's in wills, it's in trusts, it's in buy-sell agreements. And most of us would probably think that saying that a purchase price will be the fair market value at the time of death is pretty darn specific. But the trial court judge saw it differently. The trial court dismissed the case and said that Anthony was right. Simply stating that a purchase price will be a fair market value at the time of death did not provide a method for determining the purchase price. So the sisters appealed. Now, the Supreme Court of Virginia looked at it this way. If you have a contract of purchase, a price is, maybe the most important term of the contract. And for that contract to be enforceable, it's crucial that the contract provide an ascertainable, certain way to determine the purchase price. And the Supreme Court of Virginia didn't look at fair market value on the date of death as being sufficiently clear and sufficiently certain to make that contract enforceable. So the Supreme Court upheld the trial court's decision, and Anthony was allowed to get out of that purchase contract. So I'm not necessarily surprised by the Supreme Court of Virginia's decision. I am a little surprised at their reasoning. I'm not sure that the court fully grasps, as much as we would all grasp, how clear and how common the term fair market value is in our world. I know we have some appraisers who are tuning in today, and I know if I went to them and said, I need the value of this business on this date at fair market value is your standard, they could do it. They'll know exactly what to do. They'll know exactly how to determine it. And they have pages and pages and chapters of books that they're supposed to follow in determining that. So qualified appraisers know how to do it. But I think what the Supreme Court was mainly hung up on was just they just felt strongly that there needed to be more of a clear method. And I think the thinking was, well, two appraisers could apply two different approaches in arriving at fair market value. Maybe one applies what's called the discounted cash flow method. Maybe one applies just an asset value, book value. Two different methods. There needs to be something more clear. So what do we do now as estate planners, as advisors? Like I said, these provisions are common. They're out there already. They're in documents now. But what do we do about new documents? And what do we do going forward? I think it's important that we be clear about the method. A lot of our documents, like in a buy-sell agreement, for example, would prescribe a method in which each side gets an appraiser. And then each appraiser goes out and values it at fair market value, and then they take the average. I've certainly seen documents where it will say each side gets an appraiser, and if those appraisers arrive at values that are separated by more than, say, 25%, then they get together, the appraisers, and try to meet in the middle, work out their differences, and if they can't, they agree on a third appraiser. Now, all of this is expensive. All of this is time-consuming, but I think it's now important, especially in light of this case, that we go through those steps and not just simply rely on the simple phrase fair market value. I want to talk about the Davis v. Davis case. It seems like every year that we do this seminar, we always have at least one power of attorney case. One case in which someone has executed a power of attorney naming a family member or friend as their attorney in fact, and then that family member or friend turns around and abuses the power of attorney and takes advantage of the incapacitated person and enriches themselves. And that's certainly what happened in Davis. Now, the facts of this case are going to sound a little bit more like a bad daytime soap opera than they will real life, but it happened, so bear with me. The case involves a man named Dickie Davis. Now, Dickie Davis loved horses, and he had a horse farm, and he trained horses. Now, unfortunately for him, he met with a bad accident while he was in his 40s still, and it resulted in him becoming a quadriplegic. So perhaps recognizing his physical limitations as a result of the accident, Dickie executed a power of attorney, naming his mother, Agnes, as someone who can act in his name. Now, time went by. Dickie moved in with Agnes. Basically, Agnes, his mother, and Dickie's sister became his full-time caregiver. More time passes, and Dickie begins to develop a relationship with one of the employees on the farm. Her name is Ray. Now, Dickie finds himself in a nursing home ultimately, and at that time, while he's sort of out of the presence of his mom and his sister, Ray continues to visit him, and their relationship gets closer. Unbeknownst to the family, Ray and Dickie get married. So a little time more passes. The family gets a call from the nursing home letting them know that Dickie is dying. They show up at the nursing home where Agnes, Dickie's mother, finds out that Dickie and Ray were married. Now Agnes, thinking probably that she's protecting Dickie, thinks, uh-oh, Dickie doesn't have a will. These assets are going to pass to Ray if I don't do something about it. So she remembers that power of attorney that Dickie had executed many years before. She begins using that power of attorney. And specifically what she does is she conveys Dickie's personal property, his tangible personal property, to herself. She then conveys his real estate, and that's where the real wealth was. The real estate was about $2 million. Conveyed the real estate from Dickie to Dickie's siblings, again, using the power of attorney. Now, it's important to note that Dickie did not know about these transfers. Agnes did not advise him. She did not consult him. So Dickie dies just about 2 weeks after the transfers are made. And at that point, everything hits the fan. Now, Dickie's brother was the executor of the estate, and Dickie's brother decides, in what's kind of an interesting move, to file a petition with the court asking the court to approve Agnes's, his mother's, actions as power of attorney. So they go to the Wythe County Circuit Court, and the Wythe County Circuit Court looks at it and says, okay, we got two issues here. The tangible personal property that Agnes conveyed to herself using that power of attorney. There's a presumption of fraud whenever someone who's an agent under a POA uses that POA to gift to themselves. And Agnes, you've got to present evidence to rebut that presumption of fraud. So that's the tangible personal property. And that wasn't worth very much, but it was still an issue. The real estate, the bigger issue that was conveyed to the siblings, the court looked at it like this. There was no presumption of fraud since Agnes didn't convey it to herself. However, it was a gift. So in order for an agent under a POA to be able to make a gift, you've got to look at the document. And you've got to find in that document where it specifically allows the agent that authority. The only thing the court could find was this language. With respect to real property, the agent under the POA could, quote, sell and convey real estate. Relying on that language, the Wythe County Circuit Court approved the transfers by Agnes. They decided that sell and convey language was equivalent to saying that Agnes could make a gift. Of course, relying on the convey part of the sell and convey clause. So it gets appealed by Ray to the Supreme Court of Virginia. Now, a couple of things to note. First, Supreme Court of Virginia noted that in Virginia, we're subject to the Uniform Power of Attorney Act. And in order to make a valid gift, the POA has to specifically grant that power. It can't just be caught up in a general power like I give all authority to my agent to act. That's not enough to make a gift. It's got to be specific. And the court looked at that sell and convey language and said, that's not a gift. That's not gift language. Sell and convey simply means you have the authority to sell the property and then convey the property to the new buyer by deed. So the court overruled the trial court and found that the POA did not grant Agnes the authority to make the transfer of Dickie's real estate. The takeaway from these cases, well, these situations, like I said before, they're common, very, very unfortunate. I'm willing to bet that most all the people on this virtual seminar, if you've been practicing long enough, you've probably come across situations in which a POA has been abused. It happens. That certainly doesn't mean we shouldn't still have our clients execute powers of attorneys. They're very important estate planning documents. But I do think we owe it to our clients to make sure that we put in certain safeguards, give them good advice about who they should name, where the document should be kept, things like that. Now, with respect to gifts, for our high net worth clients, gifts are an important part of estate planning. And it's important that the power of attorney allow the agent, in most cases, now there's always exceptions, but for high net worth folks, it's important that the POA allow the agent to continue that pattern of making gifts and make strategic gifts that will help reduce a future estate tax burden. And it's not something we should be glossing over. It's an important part of any discussion with the client about a POA. Now, with this next case, whenever I do these seminars, you can tell I try to not only choose cases that have some applicability to our practices, but I also try to choose cases with interesting facts. And I think that's certainly the situation we have in the Bonner case. Now, hopefully this is not a set of facts that you'll deal with, but the issue in the case is something you'll deal with. I'm sure you have dealt with already. In this case, we had a decedent named Jimmy Gadban. Now, Jimmy owned a construction company, and like many of us, he had a 401k plan, and he would regularly contribute to that 401k plan. Now, you know when you set up that 401k plan at your work, how they put a document in front of you, it's called a Beneficiary Designation form. And rarely are you able to even get that plan set up without executing that document. But somehow Jimmy was able to do it. Apparently, he never did execute a beneficiary form. So what you do in that case, when the person dies, what's going to govern is the plan document itself. And the plan document itself said that in the absence of a beneficiary designation form, the remaining assets of the 401k would pass to the surviving spouse. Now, there's about $720,000 in this 401k, so not a small amount. Now, for most people, determining who your spouse is not very difficult. But this is Jimmy, and Jimmy had a more interesting life than the rest of us. Jimmy was married in the 80s. He was divorced in 1987 from his first wife. A few years go by, Jimmy gets married again to a woman named Martha. That's 1995. He's only with her for about a year. Jimmy leaves her and meets a woman named Eliza. Now, him and Eliza began living together in 1995, soon after he left his second wife. But they don't get married until 2005. Now, if you've been listening closely, you'll notice there's a big important fact missing. I never said when he divorced his second wife. And the reason I didn't say that is because it doesn't appear that he ever did. So it doesn't appear that there was a legal divorce before he got married to his third wife. So all of a sudden, this issue of who gets the 401k plan is less clear. It gets a little more interesting. Jimmy's kids from his first marriage were the administrators of his estate. They didn't like his wife, his third wife. So they catch wind that, wait a minute, this is an issue. So they contact the second wife, and they work out a little side deal with the second wife. Basically say, you challenge this 401k plan, we'll support you, and then we'll divvy up whatever we're able to recover. So the second wife, who Jimmy hadn't even seen in more than 25 years, makes a claim as a beneficiary of the 401k plan. They, of course, go to court. Now, the court noted that Virginia law does not recognize a bigamous marriage, and that's what the third marriage would have been. The fact that Jimmy and his third wife had been living together as husband and wife, the fact that they fully thought they were married legally, didn't matter. It didn't matter that the third wife was completely oblivious to all this. It didn't matter that she fully anticipated inheriting her husband's, her purported husband's estate. None of that mattered. Because there was not a legal divorce, the third marriage was not valid. Therefore, the second wife, who again hadn't seen Jimmy in over 25 years, gets the windfall of the 401k plan. Now, as a side note, I mentioned to you before that Jimmy's kids from the first marriage were serving as administrators of the estate. The court was not happy with them. When the court found out that there was this little side agreement, the court was not happy. Court did not feel like that's something administrators should be doing, so they were forced to resign. the takeaway from this case, very obvious. While hopefully we don't have those sets of facts, we do often run into this issue of beneficiary designations, whether it be a retirement account or whether it be life insurance or whether it be a POD or a TOD on a brokerage account. These are very real issues, and clients do often forget to update these things. And one of the ways it can cause a problem is we draft these beautiful wills and these trust agreements, but if the assets under these beneficiary designations aren't going to the right place, if they're not making it into those wills or trusts, then those wills or trusts are not going to be effective, and the client's family are going to be very disappointed. Now we got just a few more minutes left. I want to end with this. It was an article that I read about the Samsung family. Now, the United States is not the only country in the world that applies an estate tax. And the Samsung, everyone knows Samsung, they're huge. They make everything. They make phones, they make tablets, they make washers, dryers, refrigerators, computers, they make everything. Well, Mr. Lee had been the CEO of Samsung for over 40 years. And during that time, he had amassed a tremendous fortune. Most of it in Samsung stock or in stock and Samsung related entities. And so when he died, he had almost $24 billion. Ultimately, the South Korean government wanted their cut. And applying their estate tax, which really looks a lot like our estate tax, they found that the Samsung family owed $11 billion in estate taxes. Now, interestingly, that $11 billion that just the Samsung family owed was more than 3 to 4 times more than the entire amount of estate tax that the South Korean government had collected the whole year previous. So this was a big number. Now, we don't need to feel bad for the family. They're all still billionaires. We don't need to take up a collection for them, but it is still a brutal tax. And you wonder what, if anything, Mr. Lee had done during his lifetime. Was he able to do some things to lessen that estate tax burden? Was he able to begin the shift of assets from his column to the column of his kids? And the reason I wanted to end with that is it ties back to exactly what Abby was talking about. It ties back to these proposed changes that likely are coming. These changes that will really change the face of everything we do for high net worth individuals. Again, if you have those fence sitters, now's the time to give them a little nudge off that fence and get them going. Each year, every year, they need to be making gifts. They need to be doing things that will help reduce their estate tax burden. Because for many of these people, that estate tax, it's like a ticking time bomb. You know it's going to go off. You don't know when. You don't know what the destruction's going to be, but you know it's there. And so there's things that they need to do. Well, we could, of course, keep talking, but I think we are right at 10 o'clock. So let me lay out the rest of our program. Our next speaker will be Steve Murphy. Steve's a partner in our Charlottesville office. He's going to dazzle us with his knowledge of generation skipping transfer taxes. Following Steve, we'll take a little break, roughly 10 minutes, but we'll reconvene here at 11:05. And then following the break, we'll be pleased to hear from Brad Reidelhoover, another one of our partners. Brad specializes in nonprofits and charitable giving. And then I'll come back at the end and have some closing remarks.
Thanks so much, Ben. Good morning, everyone. Wait, do I advance this myself? All right, here we are. So good morning, I'm Steve Murphy. Thank you so much, Ben. I'm a partner in our Private Wealth Services group in the Charlottesville office. I drove over from Charlottesville today for this. I think we were all hoping that we could all be here in person, and we really look forward to getting together with you guys soon in person. My presentation is on the generation skipping transfer tax, and I'll talk about a few reasons why that might be a topic to really discuss with your clients, especially now in these uncertain times of potential changes in the tax law. I'll also say that I was also hoping to give this presentation in person. The last time I gave this presentation, there was a big white wall behind me. And so the IT people said that didn't look very, very good. And so they said, we'll put something behind you like a little prop. So they brought in a plant. It wasn't quite a plant. It was actually like a tree. It was this gigantic tree they put behind me to break up this white wall. And I was worried that if I mentioned the tree or joked with the audience about the tree, then all they'd be thinking about is the tree, not the GST tax, but the tree. So when I think about this presentation, I remember the last time I gave it, I kept thinking, don't mention the tree, don't mention the tree, don't mention the tree. Well, fortunately, we've got a great setup here, and I hope everything goes smoothly. I'm going to advance the slides through this PowerPoint presentation, and we'll go from there. All right. So the generation skipping transfer tax has long been a source of confusion and complexity and yes, liability for practitioners and trustees and beneficiaries. But if it's understood properly and applied correctly, it can provide a way to transfer wealth across generations, protect assets from creditors, and save estate, gift, and this additional generation skipping transfer tax. So this presentation we'll do is walk through an overview of the key concepts, rules, and also some pitfalls of the GST tax, and then also elaborate on some planning strategies. I think given the fact that there are some changes in law that might be coming, we're probably going to focus more on some of those interesting nuances and planning strategies. But I want to make sure we walk through the history and some key concepts of the generation skipping transfer tax first. All right, so I'm on page 6 of the materials if you'd like to follow along. The GST tax was enacted in 1986, and it was enacted to address a perceived abuse of the estate and gift tax regime. And here's the way I explain it to my students in the seminars I teach at UVA Law School, and also to my clients. This might be helpful. That before the GST tax was enacted, there was a perception that wealthy families could avoid estate and gift tax over generations by structuring their gifts in the right way. Recall that that until 2000, the estate tax exemption was very low, and it applied to many people who had accumulated really any kind of wealth. Well, those individuals would leave their assets to the next generation, presumably, and at their death, it would trigger estate tax. Then at those individuals' death, let's say the second generation, they would leave it to the third generation, it would trigger estate tax, and on and on. That is, each generation would receive the assets and would have to pay estate tax. There's a perception that very wealthy families or individuals could avoid taxation at those different generations by skipping a generation. So instead of generation 1 leaving the assets to generation 2, generation 1 could leave the assets all the way to generation 3, and then when generation 2 died, there's no estate tax. Or maybe even better, generation 1 could set up a long-term trust that for the benefit of generation 2 and generation 3 and on. And as long as state law permitted it to last a long time, that trust could avoid estate tax for a few generations. So there's a perception that very wealthy individuals or individuals who had access to this complex planning could avoid estate tax at every generation. So Congress stepped in to address this perceived abuse. So what the GST tax is a tax on attempts to skip a generation and pass assets not just to your children, but to grandchildren or further generations without triggering estate tax. So with that in mind, the real goal of the GST tax is to approximate what it would look like if there was estate tax applied at every generation. Some concerns about the generation skipping transfer tax. It applies to these types of skips of not only transferring assets to the third generation or younger, but also in trust for their benefit. And one concern is that the GST tax might be imposed long after the initial transfer. The estate tax is imposed upon an individual's death. The gift tax imposed upon an individual making a transfer. But the GST tax might sort of lie in wait for years and years and only apply years later. And there's reasons why we might want to be especially careful about the GST tax in this type of a tax environment. Now, every individual has an exemption from GST tax, and that's a very important and valuable exemption to apply in the right way. And we'll talk in a moment about the development of that exemption. But right now, that exemption is historically very high. It's $11.7 million per person for 2021. That's an index for inflation. Now, there's a proposal to have that exemption cut in half to about $5 million index for inflation, which would be probably in the neighborhood of $6 million per person in 2022. To the extent a transfer is not exempt from GST tax, and to the extent that it is one of these generations gifts, which we'll talk about, there's a flat rate of 40% of tax. So it ends up being almost very punitive of this cut of the assets that are transferred. So let's talk just a little bit more about the history of the GST tax. I find this fascinating. And I like to talk about this history and background because it shows us that practitioners have been thinking for a long time about how to address the GST tax. Robert Sitkoff and Max Schanzenbach did a study in 2005 of state laws and how states were competing for trust business. States like Delaware, South Dakota, Alaska, Nevada, Wyoming have been developing these laws to try to attract more and more trust business. What Sitkoff and Schanzenbach found that once the GST tax was imposed, this caused a real shift in states. That states tried to attract more trust business by waiving their rule against perpetuities, by allowing individuals to set up trusts that last for a longer time, or maybe even indefinitely. And this was presented to individuals as a way to place assets into these trusts and avoid the estate and gift and now GST tax for generations to come. And they actually found that it seems to have worked, that through 2003, a state's abolition of the rule against perpetuities had increased the reported trust assets by about $6 billion and its average trust account by about $200,000. That's only 2003. By the way, Sitkoff and Schanzenbach did another study of whether adoption of domestic asset protection trust statutes had also increased trust business, and they actually didn't really find evidence that had gathered more trust business to that state. Now I'm on page 8 of the materials. And here we go again, just a summary of the GST tax exemption. So here's a list of the development of the GST tax exemption. Like the estate and gift tax, it's been in flux since 2001. And you can see that the exemption in 2001 was just $1 million. And now it's all the way up at $11.7 million. Again, a very valuable exemption. If you can apply that exemption to a transfer, then you can transfer assets to skip persons, but you can also set up trusts that will be forever exempt from GST tax and never have to pay that GST tax. It's a point that we're going to return to. So over the last several administrations have proposed changes to the estate and gift tax and also the GST tax. The Obama administration had an interesting proposal. They would propose to set the GST tax exemption at $3.5 million per person, obviously much lower than it is today. The Obama administration would also propose that after 90 years, a trust's GST tax status would reset. It's not quite clear what that would mean in practice, but it seems to mean that after 90 years of a trust's existence, the trust would no longer be fully exempt from GST tax, and any additional transfers to those grandchildren or further generations would trigger GST tax. Now, that might seem like an important shift, but we want to remind clients that the GST tax has only been in place since 1986. And the Obama administration had suggested these trusts could still last for 90 years. That would be a long time. They could even last, and who knows how the law might change in the time period, in the intervening time period. The Trump administration had proposed to repeal the GST tax, but it only succeeded in doubling the exemption. And obviously the Biden administration has proposed numerous changes to the estate and gift and GST tax laws. He had initially suggested reducing the GST tax exemption to $3.5 million. Now the suggestion or the proposal is to reduce it to $5 million per person. And as you may know, he also had suggested eliminating the step-up in basis for income tax purposes upon death. That's another point we'll return to about taxation of these transfers. And obviously, these laws are continue to be in flux. All right, so maybe a few comments about planning based on this current tax framework. So obviously, right now, it's a very high level of GST tax exemption, which is a very valuable exemption that would allow these trusts to avoid estate gift and GST tax for years to come. There's also a principle called portability that we don't want to forget about. As a reminder, portability is a principle that allows spouses to share or double up their estate tax exemptions and gift tax exemptions upon the death of one spouse. So just as a reminder, if a husband dies, he might have, under current law, $11.7 million of estate tax exemption. If he passes those assets to his children, that uses up that estate tax exemption. But if he passes those assets to his wife, then that transfer qualifies for the marital deduction, and now the wife would have all the assets in her name, but she would only have her own estate tax exemption to pass those assets upon her death. Portability is what our late colleague Dennis Belcher used to call a game changer. What portability allows the wife as the surviving spouse to do, or as the executor of the husband's estate to make some tax elections so the wife could pick up and use the unused estate tax exemption of the husband. So under prior law, when there was no portability, clients felt a lot of pressure to use their estate tax exemption at one spouse's death, otherwise they would lose it. That is, upon the husband's death in our example, he might feel pressure to set up trusts for the benefit of his wife and children to use that estate tax exemption, otherwise he would lose it. But in the current climate, he could just pass his assets to his wife or to whomever he would like, and then to the extent that he didn't use his estate tax exemption, his wife could pick up and use that unused estate tax exemption. And portability gives our clients a great amount of flexibility. But there's a key distinction with GST tax. GST tax exemption is not portable between spouses. That is, if the husband wants to engage in this generation skipping planning, if he wants to make sure that he can use his GST tax exemption upon his death, and he needs to make sure that, number one, he has assets in his name at his death that could be used to apply that GST tax exemption. And secondly, he needs to take steps at his death to set up structures that use that GST tax exemption. So in many ways, GST tax planning puts us back in the older regime where we want to make sure each spouse has sufficient assets in their name to use that exemption. All right, so just a few comments about the GST tax and how it works. And what I want to do is point out just a few ways that clients might be surprised or think this might be unfair. And one example is the actual transfer itself. In making a transfer to these further generations, or in setting up these types of trusts, it's important to identify who the transferor is, because only the transferor, from GST tax purposes, can use his or her GST tax exemption to make the transfer exempt from GST tax. And on page 12 of the materials, there's a summary there. Obviously, if you have the assets in your name and you transfer them, then you're the deemed transferor for GST tax purposes. So you can apply your exemption to those transfers, but you cannot apply your own exemption to a transfer by someone else. And this could lead to unexpected or frustrating results. Yeah. I'm looking at example 1 on page 13. So here's an example. Upon the death of grandfather, he sets up a family trust for the benefit of grandmother and thereafter their descendants. Grandfather died in 2001 at a time when he had a low estate tax exemption, and thus his estate was required to pay estate tax upon the funding of the family trust. But importantly, grandfather had insufficient GST tax exemption to make the entire family trust exempt from GST tax. What this means is that eventually, upon the death of various individuals, that trust might trigger GST tax or be subject to other tax rules, which we'll talk about later. Grandmother dies in 2021. At her death, she has sufficient GST tax exemption of her own. So if she could simply apply more exemption to that trust and make it fully exempt from GST tax. However, because grandfather was the donor of the family trust, grandmother cannot allocate her GST tax exemption to the family trust. So therefore, at grandmother's death, the trust would continue on not fully exempt from GST tax. And clients often find this a frustrating result, but it's one to anticipate. And we'll talk later about maybe some steps the family could take during grandmother's lifetime to allow her to use her GST tax exemption and apply to the trust upon her death. So there are a number of important concepts and definitions which are summarized in the materials. I don't know if we need to go through them in great detail, but just by way of just brief introduction, one concept is a skip person. A skip person is someone in your family line who is 2 generations or more below the donor or the donor's spouse. For others who are not in that family line, generation assignment is based on 25 years. So you are in the middle of your generation. So if you think of someone who is 1 generation below you, that person is 12.5 years younger than you. Anyone younger than that is in the next generation. So for someone who's not related to you in your family line, a skip person would be someone who is more than 37.5 years younger than you. Now I'm 42, so I look around at some young children and those are all skip persons. There's a important concept called the predeceased child rule, and this is summarized in page 15 of the materials. The predeceased child rule states that in determining someone's generation assignment, if at the time of the transfer for GST tax purposes, if a generation is deceased, then the people below that generation all move up. So an example might be at the time of father's death, he might have a living son and 4 living grandchildren. If that's the case, the 4 living grandchildren are all skipped persons. However, if at father's death the son was predeceased, then those 4 grandchildren would have bumped up, and now they're determined to be the next generation for GST tax purposes. Again, that's all dependent on who the transferor is and the time of the transfer, but that generation assignment can be an important consideration. In the materials also, starting on page 16, there's references to direct skips, which is actually a transfer to people who are, or in trust to individuals who are all skip persons. And then indirect skips, which would be a transfer to what's called a Gst Trust. Now, a Gst Trust is a very technical definition found in the statutes and regulations, and that's going to be an important definition we'll touch on later when we talk about allocation of GST tax exemption. But importantly, intent doesn't really matter here. It doesn't really matter whether a client intends to set up a trust that might last for generations or generations. Instead, it's all about the specific qualities of that trust and whether it might trigger state tax at a certain individual's or generation's deaths. So we'll get back to that definition as well. The materials also have some summaries of taxable events, such as direct skips and taxable distributions and taxable terminations. I'll just make one comment that the trustee of a trust is responsible for reporting regarding the GST tax treatment of that trust. So if there is a direct skip, then the executor or the trustee would be required to consider whether there's GST tax due. A taxable distribution from a trust is a distribution from a trust that is not fully exempt from GST tax to a skip person, to someone who is identified in terms of the establishment of the trust as one of those people who are 2 or more generations below. Upon the taxable distribution, there might be GST tax due, and there's a specific form that the trustee would file called 706 GSD. Now, we're finding that a lot of fiduciaries nowadays are filing that 706 GSD, that GST tax form, even if the trust is exempt from GST tax, even if they don't think any GST tax is due. And this might be for a few reasons. Number one, trustees just might be worried about their liability. If they make a distribution and it turns out to be have triggered some GST tax, you might want to put the IRS on notice so the IRS could challenge that status and maybe cut off some lingering liability the fiduciary has. But also in looking at the instructions, that they actually suggest, the instructions of 706 GSD, they actually suggest that you would file this form in the case of any type of distribution, even if it triggers no GST tax. So I would just also caution you there, as you're administering a trust, consider whether that form should be filed, even if you think no GST tax is due. A taxable termination is also an important time period in the duration of a trust. A taxable termination is the time in the trust, an event in the trust, where upon that event happening, the only beneficiaries of that trust are skip persons. That is the last death of a specific generation when the trust sort of moves down to the next generation. At that time, GST tax is due on the entirety of the trust assets. And we'll talk about that, triggering GST tax, and also maybe some ways to plan around that a little bit later on. Now, the move down rule is just a concept I'll just mention very briefly. And this has to do with how GST tax works, or the effects of GST tax. Remember that if you apply GST tax exemption to a trust, then that trust is exempt from GST tax forever, as long as you don't, as long as you administer the trust properly. So as individuals die or as distributions are made, no GST tax would be due. However, if GST tax is due for a trust, such as upon a taxable termination, that doesn't mean that the trust has settled its GST tax liability forever. Instead, it just means that all the generations are essentially deemed to move down one generation. So now, at the death of the next generation, there will be more GST tax, and again, more GST tax. It's an important consideration as we think about long-term planning for the GST tax. There's a ratio called an inclusion ratio where you actually determine how much of the trust is exempt from GST tax, and that's referenced in page 19 of the materials. All right. So now a few comments about how to allocate this valuable GST tax exemption. My wife and I are from a small town on the eastern shore of Maryland. My brother likes to joke that there's two ways to get to the eastern shore of Maryland, accidentally and on purpose. And I think there's two ways to allocate GST tax exemption, accidentally and on purpose. So how do you do it on purpose? Or how do you do it accidentally? It's through something called the automatic allocation rules. And then how do you do it on purpose? It's through affirmative or manual allocation. Now, we just got through gift tax return season when gift tax returns were due just last week. But that method of allocation is a really important component of filing a gift tax return. Okay, so how do you affirmatively allocate GST tax exemption to a transfer or to a trust? Well, for lifetime transfers, that allocation is made on the gift tax return, Form 709. And I'm here on page 19 of the materials. Now, there's a specific schedule or page in the gift tax return where you could actually list where you're affirmatively allocating GST tax exemption to a trust, and then you would attach a notice of allocation that, again, puts the IRS on notice that this trust will be exempt from GST tax. Similarly, transfers at death, there can be affirmative allocations of GST tax exemption to a trust, and that is done on Schedule R of the estate tax return. And that should be listed very specifically on that estate tax return. Now, this could also result in perhaps a trust not being fully exempt from GST tax. If a trust is not fully exempt from GST tax, that could be a problem because then its distributions are made, a portion of those distributions might be subject to GST tax. So there's an example on page 21 of the materials about how to handle a late allocation during life. That is, what if you have a trust that has not been made fully exempt from GST tax? So as example 7, over time, grandmother has been funding an irrevocable life insurance trust, an ILIT, with crummy gifts every year in a total amount of $180,000. The gifts qualify for the gift tax annual exclusion, but she has had to allocate GST tax exemption for each transfer. That is, she has used up $180,000 of her GST tax exemption. So by 2019, grandmother has her full $11.4 million of gift tax exemption, but only $11.22 million of GST tax exemption. So what she does is she funds a trust for the benefit of her children and grandchildren with all of her gift tax exemption, $11.4 million. The problem is, if she allocates GST tax exemption to that trust, she can't allocate enough to make it fully exempt from GST tax. So the transfer doesn't trigger gift tax, but the trust is not fully exempt from GST tax. So what can she do? Well, during her lifetime, what she could do is find ways to allocate some additional GST tax exemption to that trust over time. And that's what she does in 2020. In 2020, there's an inflation adjustment to her remaining GST tax exemption. So she gets an additional $180,000 of GST tax exemption. Isn't that great how the math worked out? And if she does nothing, then the trust continues to be partially exempt from GST tax. But what she could do is she could just allocate $180,000 more of her GST tax exemption to the trust to make it fully exempt from GST tax. So consider this issue. As we have these small inflation adjustments every year, if you look back and see a trust that is not fully exempt from GST tax, it might be a good opportunity to think about correcting or fully making that exempt from GST tax. Now, the LATEC allocation rules are based on the value of the trust at the time of allocation, and those are very specific and complex rules. The example here just used cash because that's easy to calculate, and we're assuming it didn't fluctuate over time. But if it used marketable securities or closely held businesses, then you have to figure out what is the value as of the date of allocation. And there are very specific rules of how to do that. And obviously, it's important to get that right so that you can rest assured the trust really is exempt from GST tax for the future. On page 22 of the materials, there's a reference to formula allocations. You might be tempted to simply allocate a dollar amount of GST tax exemption to a trust with the thought that maybe this makes it fully exempt from GST tax. But we like to put in a formula allocation. These are actually allowed by the Internal Revenue Code, where instead of saying I allocate, let's say, $180,000 of GST tax exemption, you would say I allocate that amount of GST tax exemption to make the inclusion ratio 0, to make it fully exempt from GST tax. And that way, if the values are adjusted on audit, the values will also fluctuate. Now, there's automatic allocation rules also, and these are especially important to understand because someone might have been allocating their GST tax exemption to transfers all along without knowing it or without intending it. And that can have two particular problems. Number one, someone might not have as much GST tax exemption left as they think, and they might actually trigger GST tax by making additional transfers to certain grandchildren or to trusts. That could be a real problem. The second problem is less dramatic, but it's that someone might have been applying their GST tax exemption to transfers that aren't very efficient for GST tax purposes. So that could be another concern of just the inefficient use of GST tax. On page 24, there's reference to the definition of what's called a Gst Trust. During life or upon death, the automatic allocation rules provide that, at least for lifetime transfers after 2001, GST tax exemption is automatically allocated to what's called any Gst Trust. Now, Gst Trust, again, is subject to very specific rules and definitions, but intent isn't really the guide star here. Someone might set up a trust for the benefit with the intent to just really benefit their spouse during life, and then afterwards, oh, sure, benefit other generations. Well, maybe their intent was that all would be exhausted during the spouse's lifetime, but the terms of that trust might have generation skipping potential, where it would stay in trust for longer time periods. So it's important to really carefully review the terms of each trust to make sure you understand how the automatic allocation rules might apply. And there's very specific rules on page 24, summarized on page 24. and also 25, just some examples of those default rules for automatic allocation. Now, fortunately, you don't have to stick with the automatic allocation rules. You can opt out of those automatic allocation rules. So if you have a trust that you think is a GST trust, but you don't want the automatic allocation rules to apply, you can opt out of those automatic allocation rules on a gift tax return or on an estate tax return. Importantly, you can also opt in to GST trust treatment. So you could also state that, well, whatever the regulations provide about whether this is or is not a GST trust, I'm going to treat this as a GST trust, and therefore it will get that automatic allocation. And again, the manner of opting in or opting out is on a gift tax return or an estate tax return, and there's very specific language and schedules you would attach of how you report that. Again, that's a very important thing to remember, and we include that in our gift tax returns. And when we review those, I'm always careful to make sure that we review those very carefully to make sure it has the right language. On page 20, let me go back. On page 28, there's a summary of just some strategies, and we're finding that CPA firms and other advisors are thinking more and more about really how to set up the best structure for GST tax. So there's a couple of options. You could just leave the automatic allocation rules in place. That might be helpful because then if there are any more transfers to that trust over time, GST tax exemption will automatically be allocated to that trust. Seems to work really well. That is, if you want the trust to be exempt from GST tax and to use that GST tax exemption, just leave the automatic allocation rules in place. The problem might be that, that might not work out exactly as you would think. Maybe the trust is not a GST trust as you thought. Or maybe there was some election done years ago to opt out of those rules. So there could be some uncertainty there about just leaving the automatic allocation rules in place. You could also manually or affirmatively allocate GST tax exemption to help clarify the exact amount. So you could maybe opt out of the automatic allocation rules and manually allocate that GST tax exemption. One problem with that, though, is if you're opting out of the automatic allocation rules, then the client has to be really careful as they make any transfers to that trust. If you've opted out of the automatic allocation rules and the client makes a transfer to the trust and doesn't tell you, then those automatic allocation rules won't apply and GST tax exemption won't be applied to that transfer, which could be a real problem later on. Some practitioners like to leave the automatic allocation rules in place or opt out of automatic allocation only for a given year and sort of revisit this every year. So you might want to think about what's your strategy for this year, but also long term. And we're finding for a lot of firms nowadays are actually, instead of opting out of the automatic allocation rules, they're opting into treatment of this trust as a GST trust. Maybe that's a good way to balance this, that you're opting into this GST trust treatment, so you're making it very clear the automatic allocation rules apply, and maybe that helps set you up for some clarity years later for GST tax. Now, one pitfall or one trap for the GST tax is based on the state tax inclusion period, or the ETIP. Just in brief summary, and this is on page 28 of the materials, trusts that at their inception are included in the individual's estate for estate tax purposes, like a QPERT or a GRAT, you cannot allocate GST tax exemption to them at that time, but the automatic allocation rules would still apply to those transfers. So you might have a GRAT or a QPERT that is set up where later on, when it's no longer included in the individual's estate for estate tax purposes, now suddenly it would trigger the automatic allocation rules, which could be a real problem and use up a lot of that individual's GST tax exemption. So you want to be very careful in setting up GRATs and QPERTs, that you do the right reporting on the 709 to make sure that you are allocating, or I really should say you're not allocating a GST tax exemption and you're opting out of those rules. So be aware of the ETIP period too for GST tax exemption. And there's some more references in the materials in page 29 and following to some more issues with late allocations and how do you allocate after the fact, or how do you opt out after the fact. Now, there's a couple of other principles about the GST tax and it might just be helpful to just pause and mention very briefly, there is an annual exclusion from GST tax. The annual exclusion from GST tax is just like the annual exclusion from gift tax, which currently is $15,000 per individual. But it works based on a very different set of rules. You may know that with the gift tax annual exclusion, you can give a check to someone for $15,000, and it doesn't use up any of your gift tax exemption. You can also put assets into a trust and give that person the right to withdraw those funds for a period of time that, again, doesn't use up any of their gift tax exemption. GST tax exemption doesn't work that way. The GST tax annual exclusion only applies if you give someone directly that check, that cash, $15,000, or if you set up a very specific kind of trust that in sum is only for the benefit of that skip person and will trigger estate tax at that skip person's death. So another pitfall is a lot of practitioners or advisors think that you can set up these trusts and fund them with $15,000 and make them exempt from GST tax sort of automatically. But you have to be very careful about how you're setting up those trusts to make sure it's applied in the right way. There's also a reference in the materials to a technique called the Health and Education Exclusion Trust, or the HEAT, which is a technique that some people like to advocate, or there's talk about it. Maybe a way to try to set up a trust for a longer time period, but not trigger GST tax. I think that's a complicated technique. You want to be very careful before advising your client to set up a trust like that. It might not work out the way you would like, or it might be challenged by the IRS. There's references in the materials to how to avoid partially exempt trusts. That is a trust that is not fully exempt from GST tax. What to do about that. We talked about allocating more GST tax exemption during life. We also talked about qualified severances at death. We'll talk. There's materials about the qualified severances at death, which is a similar topic. All right. So we've got about 20 minutes left, and what I want to turn now to is some specific strategies for planning for the GST tax, especially in this time of high GST tax exemption, but all this uncertainty. And I want to talk about one concept called the Dynasty Trust. And I like to talk about a Dynasty Trust. Dynasty is from the Greek dynasteia, and I put the Greek up there, meaning power or dominion. But what dynasty has come to mean in English is a succession of rulers. So dynasty doesn't just mean power for a long time. It means power based on a lot of people. So the great example of that is a sports dynasty. Sports dynasty doesn't really just mean one team's won multiple championships. It means that one team has won multiple championships with multiple players. You really have to have that transition. So whenever there's talk about sports dynasty, and we can think about certain individuals or franchises that have done really well in the last several years, you have to think, well, is it really a dynasty? Has it really had that change of personnel where you can really now call it a dynasty? It's a great thing to talk to your friends about during sporting events, whether this really is a sports dynasty. You could also call this a perpetuities trust. That's from the Latin perpetuite or perpetuitas, meaning continuing throughout. And again, numerous states have abolished the rule against perpetuities to allow trust to last perhaps forever, or perhaps for some time period. In the materials, I mentioned that I believe there's only now 2 states that still have the common law rule against perpetuities: Alabama and New York. Texas just passed a law extending its perpetuities period to 300 years. But again, I like to use the term dynasty trust. I think it puts the focus in the client upon changing personnel over time. Different generations, different individuals, helps them to focus on that and not just the time period. And by the way, as long as we're being snooty and quoting languages, I like to quote Greek and not Latin. So again, that's just my preference. All right, so how does a dynasty trust work? A dynasty trust is designed, again, to allow distributions for multiple generations, to protect assets from creditors for those multiple generations, to maybe last indefinitely, waive that rule against perpetuities. A dynasty trust typically does not allow lump sum payments over time or mandatory payments over time. Instead, the default is that the trust can stay in trust forever, the assets can stay in trust forever, and distributions can be made in the trustee's discretion. You might allow limited powers of appointment at every generation. You might allow each generation to sort of decide where his or her share goes after that. But again, the default would be that it lasts for a long time period. And usually the Dynasty Trust, again, is designed to be made exempt from GST tax, so you don't trigger that transfer tax at every generation. At the bottom here, we can talk about the types of assets to fund a Dynasty Trust. Obviously, the really great assets to use from a tax perspective would be assets that would appreciate significantly over time to grow the assets in that trust. We often think about irrevocable life insurance trusts as maybe not a great candidate to use GST tax exemption, but that might be because lots of ILITs are focused on providing for the surviving spouse. But if you think about a Dynasty Trust, it might be great to fund that with a life insurance policy. Because in that case, upon the individual's death, suddenly the trust gets funded with a huge amount of money. So again, it's sort of a nice leveraged asset, put a lot of money into that Dynasty Trust. A lot of clients these days are thinking about that elusive family cottage, the family vacation home. They think, oh, let's put that family home in the Dynasty Trust. And I have to caution them, that might be great from a non-tax perspective to have this house owned in a trust for a long time period. It's not really efficient from a tax perspective. And that's because we really want assets in the Dynasty Trust that will appreciate over time. The family cottage often depreciates over time. That is just, might just be falling down, even though they see it as this wonderful, haven for their family. It's going to cost money over time. So it might not have the tax benefits they like, but it might certainly have the non-tax benefits. So maybe in closing about Dynasty Trusts, now is a great time to be talking to clients about Dynasty Trusts and using that valuable GST tax exemption while they have it. Here's the real problem, though, and sort of to be honest. The way I like to approach estate and tax planning is we talk to clients and say, let's set a goal. How would you like these assets to pass upon the death of you or maybe your spouse? How would you like these assets to continue upon the death of your children? So we'll set the goal. And now let's work towards that in a tax-efficient way. Dynasty trusts aren't for everyone. Some clients love the idea of these long-term trusts, but I have another client who gave me permission to quote this. One client, I was working with him on these trusts, and he wanted the trusts to start paying out mandatory distributions to his grandchildren and great-grandchildren. And I said, that's not really an efficient way to use GST tax exemption, and I explained why. But he said, well, let me get this straight. We're talking about my great-grandchildren who probably will have never met me or won't remember me. And all they'll really be doing is having this trust where they're fighting over my money. And he had a great line. He said, I'm not interested in writing the script for that soap opera. Just a great line. So again, Dynasty trusts aren't for everyone. You really want to understand what are the client's goals, these long-term goals, and does it make sense? Now that's in a perfect world. The problem is that Congress keeps talking about changing these laws and GST tax exemption, and so it puts a lot of pressure on clients to rush out and set up these trusts. So we liked the idea in 2018 that we were going to have this exemption in a predictable way until 2025. We could talk to clients about their goals, help them think it through, and then if it made sense, they could sort of pull that proverbial trigger and transfer and fund the trust. But we and a lot of firms now are getting a lot of clients who really want to rush to set this up. And you want to make sure it's the right decision to set up this type of trust. There's references in the materials to charitable trusts and GST tax. Just another issue there. A lot of clients think that it might be easy to make a charitable trust exempt from GST tax, or it might be a great vehicle to, this could be the initial stage of a long-term GST trust. It is complicated and difficult and sometimes impossible to make a charitable trust exempt from GST tax. So just another pitfall to be thinking about. And again, there's references in the materials on page 45 and following to these to the ETIC concerns there. All right, we've got about 10 minutes left. I want to talk briefly about a way to a technique to maximize tax savings in this environment. It's called the springing general power of appointment. So as you may know, a power of appointment is a power given to a beneficiary or other person where they can distribute or appoint the assets at a certain time to other individuals. That's called a power of appointment. If it is a limited power of appointment, that does not trigger estate tax at that individual's death. If it is a general power of appointment, then that does trigger estate tax at an individual's death. So with that in mind, let's think about some problems you might have with a GST tax or GST trust. If the trust is not fully exempt from GST tax, then at someone's death, at one of these taxable terminations, GST tax might be due, and that's at a hefty amount, 40%. But another problem with that is because those assets aren't included in the individual's estate for estate tax purposes at the taxable termination, there's no step up in basis for income tax purposes upon the individual's death. Well, that might be even harder to swallow. If you look at the current estate tax exemption, many beneficiaries have plenty of estate tax exemption. So even if the assets were included in his or her estate, it wouldn't trigger estate tax. So how can we take these assets that will trigger GST tax and move them into the beneficiary's estate? They might not trigger any estate tax, and they'll get that step up in basis. Well, the way to do that is through a springing general power of appointment. So here's how it works. You might have a clause in the document that states that upon an individual's death, if certain thresholds are met, like maybe if GST tax will be due, or if maybe there will be some tax savings if we have this power, then that beneficiary whose death would otherwise trigger GST tax will have a general power of appointment over the assets. That means the assets are now included in that individual's estate for estate tax purposes. That cuts off the generation skip, and now they are the transferor for GST tax purposes. And we have those nice benefits. It might not trigger any estate tax at all. By the way, even if it does trigger estate tax, you get that step up in basis for income tax purposes. There's sample language on page 47 of the materials where just included some language there that you might include. One problem with that language, though, is it's way in the back, and clients aren't really paying attention to that specific power of appointment, although there's lots of decision points here. So some disadvantages and responses. So number one, if a beneficiary has a general power of appointment, well, that might work for estate tax purposes, but under a given state's law, that might actually subject the assets to claims of his or her creditors, which could be a real problem. Another problem is the beneficiary, might actually exercise this power of appointment. It might work really well for the family to give this beneficiary a power of appointment in favor of certain individuals. Or his or her estate, that general power of appointment. But if the beneficiary exercises it, now suddenly all the assets might be misdirected in a way the family didn't anticipate. So again, they might actually exercise it in a way that interferes with the donor's goals. And also, it might just not have overall savings or benefits from a tax perspective or other perspective. So what are some alternatives? Well, one alternative is instead of giving this automatic springing general power of appointment, you could give a third party, usually called a trust protector, the power to grant or remove that general power appointment. That might be really helpful because it gives someone else the ability to adapt to what are the circumstances at that time. Do they grant the power? Do they remove the power at that time? Now, one problem with that, though, is now you're just kicking the can down the road. Now you're assuming that people are aware of this issue, that the trust protector is going to make the right decision to grant or remove that power. So it's not perfect, but maybe this is a way to address and build in some flexibility over time. You also could do a formal modification of the trust, a very formal modification that states that, okay, now this beneficiary has this general power appointment. One disadvantage of that formal modification is, you might modify the trust in that way, but then you might regret it. Well, then you've got to formally modify the trust back. There might be some ways to try to address that. But when we do a formal modification, I always try to remind clients of what the risks are. And I think that's helpful just to show everyone what really could go wrong. If you grant a general power of appointment to a beneficiary, they might actually exercise it, and then suddenly the people don't get the inheritance that they wanted to. Or maybe it's subject to claims of creditors, or there might be other issues. All right, so for the last 5 minutes, I want to mention one other issue which is really important, which is modification of GST trusts. Uniform Trust Code provides any number of ways to modify trusts. And that might be really attractive to people, to modify trusts over time, just to tweak the administrative provisions or change a beneficiary's interests or change a trustee or the like. But you want to be very careful about modifying any GST trust, because even simple modifications or things you might seem to be simple might actually undo that all-important GST tax exemption or exempt status of the trust. It might mean that the trust now has to pay GST tax in the future, or gosh, even worse, I think it might even mean that the trust suddenly owes GST tax right now. So there are rules in the there are provisions in the regulations which give very specific, rules or provisions about the effective date of GST tax and how modifications work. And here on the slide, you can see at the bottom, there's a few general provisions. What if there's a settlement among the beneficiaries about the trust terms? What if there's a judicial construction? Or what if there's other administrative changes like changing a trust to a unit trust? All those things might seem very simple and straightforward, and we might do them all the time. But if there are GST trusts, there's suddenly a lot more at stake. So what I like to do with clients is early on, just flag the issue of GST exempt status when they're thinking about a modification. Because here's what I want to prepare the client for. The client might walk in and say, I've read stuff online. I think it'll be really easy to change this trust. Or other advisors might have told them, it'll be really easy to change this trust, won't be complicated, won't be a lot of risk involved. But what I want to do is caution them very early on that if it's a GST trust, we want to be very careful. And that might include more analysis. It might include even a private letter ruling. It might include a court approving what we're doing. So again, you set the stages very early that if you want to make this change, we got to be aware of the GST tax issues. Now, there are two specific safe harbors for certain modifications that we rely on a lot, and that's for a modification of a trust called a decanting. Now, a decanting is a trust, or is a term borrowed from the wine industry, where assets are taken from one vessel and put into a second vessel. And in terms of wine, that helps to air out the wine or remove impurities and the like. In terms of a trust, you're taking assets from one trust and putting them into a second trust or maybe a modified trust with slightly different terms. And under a lot of states' laws, as you may know, as long as you comply with these specific rules and procedures, that modification is effective. Well, that's a great tool to modify a trust, but again, we want to be very careful to not undo that GST tax exempt status of the trust. There are two safe harbors in the regulations that allow decanting of a GST exempt trust without undoing that exemption. And I've just summarized them here. First, if the initial terms of the trust allow decanting, maybe if it's a newer trust or if the discretion is broad enough that that discretion existed for a long time. And if you don't extend the vesting under the perpetuities period, then that decanting won't undo the GST tax exempt status. Then there's a more general safe harbor that says if you don't shift an interest to a lower beneficiary, then again, you can modify the trust. But again, these are deceptively simple. You want to be very careful as you're applying these rules, and you want to make sure you have the right safeguards in place so you're navigating the risks in the right way and not, again, accidentally triggering GST tax or triggering GST tax years in the future when all these steps have all been finished. All right, so just a few other administrative issues to think about for GST tax. Hopefully today I've summarized. We've got a lot of pitfalls, but also some opportunities here for GST tax. But you want to make sure that you understand what is the GST tax exempt status of any of these trusts. And I like to encourage clients, especially when they're onboarding a trust or setting up a trust, to really get their heads around what is the GST tax exempt status of that trust. I joke with my students at the law school that there's no such thing as a stupid question, but there is a stupid time to ask a question. So asking what is the GST exempt status of a trust, that's a great question. Asking that question after you've made a huge distribution to a grandchild, that might be a stupid time to ask the question. But onboarding that trust is a great time to say, hey, let's gather all the gift tax returns, all the estate tax returns that might apply, and let's really figure out what is the GST status of this trust. And again, it alerts clients too that this is a complicated issue we want to be paying attention to. It's especially problematic or important nowadays because a lot of clients think the GST tax just doesn't apply to them at all because the exemption is so high, and you want to caution them against that. All right, so here we are again with the GST tax that it can be this source of confusion and complexity and, yes, liability, but if it's used in the right way and if this exemption is applied and maintained the right way, it can provide this great foundation for transferring wealth over generations, fulfilling the donor's intent and avoiding any of these pitfalls. All right, so we're here right at 10:55. We're going to take a break now for 10 minutes, and then we'll come back for our next speaker. Thank you very much. And I look forward to seeing you all in person soon.
Well, welcome back. My name is Brad Ruddle-Hoover. I'm a partner in the Richmond office, and I get to go up last. Thanks, Steve, for a great presentation. We're now going to be talking about charitable giving. And obviously, we've had lots of legislative changes from 2017 to things that came about in the pandemic period. And now the question is there more? And I don't have a crystal ball, so I can't tell you what's going to happen in the next month and a half, 2 months, and whether or not we're going to see dramatic changes in the legislation, tax legislation, and then what would happen because of it. But we're going to look at some of the proposals today. We're going to see how those proposals might impact charitable giving. And as you're thinking about working with clients or working with donors, people that are philanthropically minded, what are they thinking about? Because sometimes we think about taxes, or I think about taxes every day. Not all donors think about taxes every day. Donors think about impact. And so we're going to think about all the different things that go into this calculation. And then we're going to finish with some topics of how strategies you might be using in this time to increase charitable giving, to give benefits to both the donors and the charities alike. But we want to get started today, and we're glad you're here, thinking about what is the state of giving, because there's been a lot of questions since the 2017 Tax Act. Is giving going to go up? Is it going to go down? Is it going to stay the same? And charities were very concerned after 2017 that there would be a decrease, because we've been having years before the 2017 Tax Act of charitable giving increasing, and the question was what was going to happen. It was increasing all the way through 2017. And the 2019 report indicated that giving declined in 18, which was the first year that the changes in the 2017 Tax Act were in effect. The expectation was that in 2019 it would get worse. It did. It continued to decrease, again, the second year that the 2017 Tax Act was in place. And then March 2020 happened. And in March 2020, we all know that we started working from home, a lot of us. And the question was, how are charities that can't hold fundraisers and events in person, how are they going to raise money? How are charities that do so much good work to help people in need, how are they going to still provide those benefits and charitable efforts if they don't have the ability to effectively fundraise? And Congress took note of that. We had multiple clients first couple of months of 2020 saying, we got to set up a charity, or we got to do something so that we can get more dollars in the hands of people that are in need. And so there was a big boom in early 2020 of figuring out ways to get money in the hands of need, whether it was employers giving money, raising compensation if they were able, or giving direct assistance that wasn't taxable compensation. There were, like I said, people trying to give more money to charity, to give out to donors. There were people that wanted to set up new charities to provide assistance to those in need. So obviously the 2020 legislation had a big effect. So there's a new report recently released in June of 2021, same report, Giving USA. Remember, 18 started going down, 19 started going down, and the question was, well, what about 2020? What's going to happen, and what should we expect? Well, maybe unsurprisingly, given the legislation that we're going to talk about, charitable giving went back up. Giving by individuals increased by 1% after adjusting for inflation to a whopping $324.1 billion. Again, this was after the decrease in 19, but I think a lot of this came from the response to the pandemic, economic need, and noticing that there was lots of need out there. There's also racial and social justice movements that raised money and had a lot of things that were going on in the charitable space. We're going to talk about today the legislative incentives that popped up in 2020 and 2021 that increased benefits for people giving larger sums. And we had a strong stock market. Even though we weren't expecting one, we had a period of time where the stock market was going up, which put people in a position of increasing wealth and gave more money. Now, overall, the giving by all types of donors did increase by 3.8% in 2020 from 2019 after adjusting for inflation. That included a big increase from foundations, 15.6% increase. Bequest went up. The cash and in-kind corporate giving did fall. I mean, I think that's not surprising. The incentives, while there were some incentives for corporations to give more money, the bigger incentives were obviously at the individual level. And obviously corporations, there's just a lot of uncertainty. What's going to happen, needs for cash flow, and make sure they have sufficient funds to pay their people and things like that. So overall, the nonprofit space had more money at its disposal, but at the same time, there's a bigger need. I think the needs that came about in 2020 and 2021 have been great, and the charities have tried to staff up and come up with ways to combat the many problems that people faced in these time periods. Obviously, people were getting some government assistance, but charities were out there doing their good work at all times. And so that was not a surprise that it went up. The question is, what's next? And what are charities looking at? But before we forecast what's next, or we look at potential new laws and how it might impact, I want to dial back quickly and not spend a lot of time, but I do want to go back and just think about where we started with before 17, how 17 changed, because it'll help you think through the 2020, 2021 changes and then the potential new changes. So back long ago, 2016 and early 2017, donors had to itemize to get charitable deductions. We're going to talk about now that there's some possibility to get a charitable deduction even if you don't itemize. But back in that time period, donors had to itemize. There was an overall cap on the Pease Amendment. It's called the Pease Amendment. Overall cap on your total itemized deductions, which includes charitable dollars. There was a 50% limit. Everyone was familiar with the 50% limit on cash gifts to certain public charities called 50% type organizations. A few others meet that category, but generally public charities, United Way, Goodwill, things like that for cash gifts. There was a 30% limit on appreciated property gifts to those same type organizations. So if you gave property that had gone up in value, you could deduct up to 30% of basically your AGI. There's little caveats there, but basically your amount of your adjusted gross income. 30% limit on cash gifts to private foundations, but special rules if you're giving appreciated property to private foundations, you're limited usually to the lower of fair market value or cost. There's a carryover if you can't use it all in 1 year, and special rules if you're donating tangible personal property or ordinary income property. So we've gotten pretty comfortable with these rules. They've been the same for quite a while and kind of knew what was going on. And then we had the 2017 Tax Act. And there were ideas in here to increase charitable giving. There were ideas of ways to allow people to give more. They were not easy to understand. There's a lot of formulas for those of you that like Excel, like myself. This was an Excel dream because there's lots of things to input and take out. But the first one was the annual limit on cash contributions we talked about being 50%. It went up to 60, maybe. Why I say maybe? Well, there's a lot of push and pulls to figure out exactly how much you can give to get to the 60%. If your client or your person you're working with is giving all cash, pretty easy, you can get up to 60%. And this change is effective after 2017 and before 2026. So there is a sunset on these. So we'll see what happens as we get further into the Biden administration, if there's any permanency to these extendings, or if we go to a new administration in 2024, what do they do, and what happens there. So for right now, there's an option under just the 2017 Tax Act, not getting to the CARES Act or things that we're going to talk about in a second, that you can get up to 60% of AGI deducted in a year. Now, I understand that's going to be impacting a smaller number of people because that's a lot of money to give away in a given year. But if you have a really big income event and you don't need the cash and want to give it away, there's ways to put it, and maybe you don't even know which exact places you want to give, but there's ways to do things to set it up to give the 60% away. There's also the change to the 80-20 rule. We're not going to spend a lot of time on that. That really impacts a lot of colleges and things that they're working on. Now, here's an area where it wasn't designed to increase charitable giving, but it could, because the tax rates went up. For a single taxpayer making more than $510,000, in a given year married making more than 612. In 2019, it went up to 37%. Now, obviously, the dollar amounts are adjusted for inflation, but you can see that rates are going up. And the proposals we're going to talk about in a little while, rates are continuing to go up. And so what happens here is as tax rates go up, the value of a charitable deduction increases because it's obviously a percentage of the dollar that you're saving from giving money away and not paying taxes on your income. But we'll question whether that really has a major impact, but there is an increase there. The Pease Amendment that affected certain higher income taxpayers suspended. So the allowable deduction is not reduced under the Pease Amendment, which was this another math formula that we're not going to go over, but your software usually calculates it when you're doing these higher income deductions. The standard deduction was doubled and personal exemptions was eliminated. So for a married couple, the standard deduction, which was around 12, went up to 24. What does that mean? It means a whole lot less taxpayers were able to itemize. So next thing you know, people that previously got a tax deduction for their gifts to their church or their local nonprofit, they don't take the deductions anymore. Now again, you go back to, well, is money tax savings driving the charitable giving? We'll see. But that was something that changed, and a lot of charities were very worried that that would result in reduced giving. Other itemized deductions were repealed, the miscellaneous itemized deductions. A lot of that's the business expenses and things like that, employee business expenses. The state tax, we talked about that before, was increased, and these changes all apply through 2025. So now we fast forward to 2020. Some of this was a reaction to changes from the 17 Act that had some negative implications or negative results. Most of this was due to we've got to figure out ways to get more money from people that are not suffering, that are having, not the difficult times, into charities' hands, and from charities' hands to the people truly in need that are facing crisis because of the pandemic. So the first thing it did, the CARES Act and the Consolidated Appropriations Act extended some of these items to 2021, but the CARES Act was in 2020, and it created a new partial above-the-line deduction for cash contributions up to $300 to very specific charitable organizations if you didn't itemize. So for those people that no longer itemize because now they have a $24,000 plus standard deduction, they're still going to get some benefit for the gifts to the local nonprofit, the church, whatever it is they're giving money to. And it was $300. Still not a big dollar amount. A lot of charities wanted this to be much, much higher. And there were some proposals, legislative proposals, to get the $300 number up. But for 2020, it was $300. There was also some confusion about if you were married, is it $300, is it $600? And it wasn't completely clear, but the IRS basically provided guidance saying it was $300 was the determination based on the guidance or the way the legislation was written. But single people and married filing separate potentially could give more. But at the end of the day, I think $300 was the deciding line. So for 2021, they said, well, let's make it clear. So with the Consolidated Appropriations Act, married couples who file jointly can deduct up to $600. Again, the point was to make sure $300 per person was deductible. But here the exception is important. You can't give this money to supporting organizations, which are Code Section 509A3 organizations, or donor advised funds. Now, reality is people that don't itemize, are they going to typically have donor advised funds? Probably not. Generally, this is going to be your larger donors. So I don't think that's going to be a big impact, but the key thing is cash donations typically to public charities are going to get the $300, now $600 deduction if you're married filing joint. The CARES Act also added something that was a much, much bigger deduction for the larger taxpayers with larger ability to give away money, is the 100%, I read that right, 100%. So if your gross income was $1 million, you could give away $1 million and pay no taxes in 2020 or now in 2021. Now, there are some limitations on this. Obviously, that has to be cash, can't be property. And we'll talk about the types of charities that are allowed the money to be given to, because there's some concerns here. But you could give away cash And you could stack this. So if you gave other gifts away to supporting organizations, private foundations, you could end up giving away the remainder of your AGI by making an election to give away 100%, and this is for individuals. Now, that was a big change. I don't know how many clients took advantage of this. We had one client that asked us to run the calculations to figure out, was it possible? Don't know if they ever ended up pulling the trigger on it, but we figured out a way they could give the money the way they wanted. The next one was corporations. The percentage they were allowed to deduct on their tax return went from 10% to 25%, so an increase. That was for 2020 only. For partnerships or S corps, each shareholder must elect to use the modified percentage limitations, so there's some consistency requirements. And then for food donations, the limits went from 15 to 25% in 2020. Notice these two changes were not extended with the Consolidated Appropriations Act to 2021. So these were big changes in 2020 and 2021, and we're going to see what happened as far as 2021. Obviously, we said at the beginning of the talk, for 2020, the amount of contributions increased from 2019. We'll see if that increase continues or if there's something else going on. Now, obviously, the goal with Congress here was to make sure that these changes would have a significant impact by getting more dollars in the hands of charities that can do good works. The lower income tax rates that came from the 2017 effect, 2017 tax rates that went down, that was definitely a change. I think I said earlier that the 17 Act lowered the income, raised the income tax rates. It actually lowered. The proposals coming up are going to increase. So I'm sorry, I misstated that. But the lower income tax rates, the question was for the 2017 Act, would it decrease charitable giving? It did for 18 and 19, and then pumped back up for 2020. Same thing we talked about, the standard deduction versus itemized, the concern, a big impact here because so many people would not itemize anymore. And again, the CARES Act did have the effect of increase. But the question is, does this really matter for your high net worth taxpayers? Are they really going to focus on these tax changes? And at the end of the day, that's a question that when we work with charities or work with donors, we ask them, what's your motivation for giving? What is your goal here? Some people, when they're doing estate planning, they say, well, I want a no estate tax plan, right? They want a plan that puts them in a position where they give the maximum amount they're allowed to give away tax-free to their children or relatives, and then the remainder goes to charity, and the Uncle Sam gets nothing. So obviously there are clients that come in with that motivation. When it comes to just charitable giving, not through an estate or trust planning, the ongoing annual giving or giving before death, the question is it really motivated by tax? And, for a lot of these people, they like lifetime gifts. Why do they like lifetime gifts? Because they get to see the benefits. They get to see the impact that their gifts have to these charities. So there's definitely a question of, what is the most important here for them. Now, obviously, gifts of appreciated property continue to offer benefits. For people that non-itemizers, there's also options through the IRA that I think you've heard about before. But the last point on here is some taxpayers who don't itemize every year may want to bunch gifts together so they can give to donor-advised funds and private foundations. Now, obviously, you have to have resources to do this because you're going to give what we call bunching of gifts. But we're going to talk about in a minute, there's significant scrutiny in the world of donor-advised funds. I even had a question before the presentation about donor-advised funds. That's something that Congress is laser focused on, and there's proposals that are currently pending that would dramatically alter the donor-advised fund landscape. And so these are options for charitable giving, but the question is what's going to happen in the future. Also, market conditions. Obviously, people's ability to give money, they need to see or feel a lot of times that they have the flexibility with the market going up. They have more available cash, more available assets. Some people are motivated by the concern there's cuts in government funding. I think that obviously was something that was always radar when you have the Trump administration in place. The question now with the Biden administration, are they going to be able to get more government funding to programs? And obviously we have a lot of deadlock when it comes to activity in Congress, given the tight split between control of the House and the Senate. And that continues to give uncertainty as to what is going to happen. Let's shift over to a few legislative proposals that are out there. Again, don't have the crystal ball, can't tell you where these are going to go, but they are things we should watch. Why? Because obviously these are the ones that we noted would have a direct impact on charitable giving and people's interest in giving money. The paying your fair share, again, 2017, tax rates went down. Now with the Biden administration and the Democratic control of the Congress, there's questions about, well, for high-income individuals, are taxes going to go up? The Biden administration has been very clear that they don't want taxes to go up for people making under $400,000. Questions about exactly how that's spelled out, and is that a married or is that singles? But for people that are earning higher amounts, to ensure this example, paying your fair share, if your AGI is over $1 million, they want to make sure you get taxed and make sure that's going to happen. So tax is 30% of excess of taxpayers' AGI over the modified charitable contribution deduction. So taxes go up here, but they actually have a carve out to make sure there's some charitable giving contemplated in that. The next one is the Secure Act 2.0. Prior presentations, you've heard about the Secure Act and all the changes it made related to IRAs. This one allows a one-time 50% distribution from an IRA to a CRT, a Charitable Remainder Trust, or a Charitable Gift Annuity, CGA. So sorry, that should be or, not of. The CRT or CGA must be solely funded for the benefit of his spouse and funded with qualified charitable contributions. So again, these two are trying to figure out ways to get money, different pots of money here, retirement, into the hands of charities, but also look at how to get the taxes up. Another proposal came in March 2009, Universal Giving provides non-itemizers with a below-the-line charitable deduction of up to 1/3 of the standard deduction for 2021 and 2022. I don't know where this one's going to go. Obviously, we have the non-itemizers we talked about at the beginning have the option right now for a $600 married or $300 single above the line. Whether they're going to throw in another category of deductions, but this one would be below the line. That one seems a little bit hard for me to swallow that's going to get passed. Be nice. It obviously focuses specifically on charitable deductions, which is good, but I think that's going to be a tough road to get that through. This last one is ACE, the Accelerating Charitable Efforts. And I mentioned just a few minutes ago that donor advised funds are highly under scrutiny. Let's talk about what is a donor advised fund, because a lot of people like to set them up in lieu of a private foundation. A donor advised fund is a fund at a sponsoring organization. Fidelity Charitable, Morgan Stanley has one. There's lots of organizations. Community foundations are routine sponsors of donor advised fund. You give your money to these public charities, so the public charities raise a lot of money, and then you have advisory rights. You have the right to advise the charity on where the money should go. So you see, it's kind of like a private foundation where you would have control. The difference here with the donor advised fund is the charity, the private foundation, or the the advisory people don't have absolute control. They can't. It's prohibited under statute. So at the end of the day, you make a recommendation to the donor advised fund sponsoring organization. They make a final determination of where the money will go, when, and how much. So the key thing when setting up a donor advised fund is find out all the things about what factors come into play when they make the distributions and make sure it matches your goal. There are donor advised funds that basically have, we will distribute to any organization that is a 501c3. There's no restrictions. There are other donor advised funds that have specific purposes, and they won't allow donations outside those purposes. So obviously, you wouldn't want to give to a donor advised fund that is outside, that doesn't meet your goals. The problem from Congress's point of view, or many members of Congress and some academics, is that donor advised funds could conceivably warehouse money. What does that mean? Well, private foundations must give out 5% of their net assets year over year, and that's just something we've had around for a long time. For donor advised funds, there's no rules currently in place. Technically, a donor advised fund doesn't have to make any distributions in a given year or over a given period of years. If the donor advisory group, the advisors to that donor advised fund, don't make any recommendations, the money technically could sit. Now, each donor advised fund has its own internal policies and procedures, and the people that are pushing back on the ACE Act are saying, in reality, these rules are not needed because donor advised funds are getting money into the charitable space. But the concern from Congress is donors are getting a tax deduction in the current year for money put into a donor advised fund that may not touch a charitable group for many years or tens of years down the road. So the Accelerating Charitable Efforts Act, ACE, would basically set up some parameters to encourage passing out the money to actual charities. Sorry, not actual charities, that's a bad way to phrase it. To charities that are operating. Charities that are actually doing direct charitable activities as opposed to a donor advised fund, which is more of a grant-making organization and not performing direct charitable activities. So when I say actual, I mean the charities that are actually performing charitable activities. Now, setting up a DAP, the qualifications, whether it be qualified or non-qualified, depends on how long the donor advisory privileges last. Most of these organizations don't have a time limit right now. The donor advisory privileges last forever. Here, if it terminates within 15 years of the date of contribution, that's going to get this qualified status. Also, the establishment of these would restrict it based on the types of community foundations. If there's a community foundation involved and there's some limitations on how that community foundation operates, that will give it more of this preferred or qualified status. If you don't qualify under the first standard, the 15-year or less, or you're not a qualified community foundation, then you're going to have basically the worst type of tax treatment. So we give you an example on this next slide that kind of walks you through all the scenarios of when you're going to get your deduction. Again, that's the key thing here is if you're not going to get your deduction immediately, you might want to restructure the donor advised fund terms, or you might want to give to a different charity. But here, a donor gives a parcel of real estate value of $200,000 to a donor advised fund in September, and the donor advised fund sells it in 2023 with a reduced amount of proceeds, obviously sale expenses, and distributes a smaller amount to public charity in 2024. Current rules, not under the ACE Act, the donor gets the deduction in 2021 based on the fair market value, which we said was $200,000. That's great. If the ACE Act is implemented, which again, no crystal ball, can't tell you what's going to happen, can't tell you whether it's going to be, but if it was, if the DAF was a qualified DAF, meaning you have less than 15 years to advise on it, or there's a qualified community foundation DAF, you get your deduction in 2023, 2 years after you donated the property to the donor advised fund. Why? That's when the donor advised fund sold the asset, realized the cash to do something with it. So you get that deduction, and it's based on, you get the deduction in 2023 based on the net sale proceeds. So you don't even get the fair market value in 2021. What's the risk there? If the value changes during that time period, you've got risk and you don't know what your deduction is going to be. So it's almost like, are you going to require them to sell in the year of gift, some sort of condition? Is that going to change the value up front? So there's a lot of concerns there. And then if the DAF was not a qualified DAF or a non-qualified community foundation donor advised fund, you wouldn't even get your deduction until 2024, 3 years after you made the initial contribution of the real estate, and your limit is down to $150. That's the amount of cash that actually went out the door that year to charity. So you can see that the incentives of having a donor advised fund, or the benefits to having a donor advised fund, are really restricted under this proposal in the ACE Act. But it gets better or worse, depending on your views on these having donor advised fund. You can't get a deduction unless you have a contemporaneous written acknowledgement. Most organizations are putting together charitable receipts, but you got to have those. And you must provide to the IRS. Today, you don't provide your charitable receipts with your tax return for donor advised fund contributions. You would have to. And if the donor advised fund, other than a qualified community foundation, doesn't distribute the property over a period of time that's required, there's going to be a tax. Now we're taking money out of the charitable world and putting it in the government hands. Again, incentives to get more money out more quickly. Finally, the couple points that should be important to private foundations. Currently, private foundations can give to donor advised funds and treat it as a qualifying distribution, which means that that 5% test I mentioned, if you're not ready to give it to a operating charity that's giving out money directly, there's currently the option to bump it over to a donor advised fund, which could potentially defer the actual money going out to a charitable organization that's operating as a charity and providing direct charitable activities even further. So some people see this as a loop, a hole here in the legislation, because the goal was to get the private foundations to put the money in the hands of operating charities. Now they can skip a step or at least delay even further. And so the ACE Act would say those contributions are not qualifying distributions and is not part of your 5% test. So you got to give other monies away if you want to give money to a donor advised fund. Also, give a little incentive, remove the excise tax on the the net investment income each year if the private foundation increases its distributions from 5 to 7%. So again, the goal here is to increase charitable giving. Lastly, the public charities. Right now, when public charities receive donor advised fund money, it is considered a public support. So obviously, public charities need to meet the public support test, which means more than 1/3, if they're a 501(a)(1), more than 1/3 of their money must come from the general public. And donor advised fund would be good support, meaning it goes in the numerator and the denominator. But here, if it's coming from a donor advised fund, unless you can prove to the charity that no one had donor advised privileges over the distribution, then at the end of the day, you have to treat that as coming from one source, which means if it's going to blow up your public support test, you're going to have problems. So that's going to be a big change for public charities. Also, administratively, a lot more work to require paperwork to prove up the public support test. And with all these administrative burdens, people are concerned that the cost of operating charities is going to greatly increase. Finally, what proposals are out there that aren't directly tagged to nonprofits and donors, but could have this impact? Again, we saw that the tax rates went down in 2017 to 37%, the top rate. Proposal right now from the Biden administration is to bump it back up to 39.6. Big one, increase the corporate income tax rate, which is a big decrease in 2017 to 21%, back up to 28%. This does affect charities that pay unrelated trade or business income tax because they pay it tied to the corporate rate. So that could have some impact on charities, not necessarily as much on the donors. The next one, the third bullet on here, another big change, capital gains. Right now, people really like to give, really are incentivized by the 20% rate on capital gains, the max that you have to pay on a gain for most long-term capital, or for all long-term capital gains. It would increase back up to the ordinary rate of 39.6. So all of a sudden, the incentive of taxing a lower rate capital gains is decreased. So what could that possibly do for charitable organizations? It could work to a point where people want to give appreciated property to charities in the hopes of avoiding paying the capital gain. Now, we always get this question when people say, all right, I have a company, I'm about to sell it, and I'm going to give a portion of those shares or stock or LLC interest to a charity. And the question is, can I do that and not pay taxes? The answer is yes, but I think that's always the answer from a lawyer, yes, but is when are you doing that contribution to charity? Are you doing it after someone's already signed a definitive agreement saying that you can't, basically the sale is a done deal? So you got an LOI signed, you have a purchase agreement signed. You know, the closer you get to the closing of the transaction, the worse chance that you're going to be able to argue that the tax is not to be paid by the seller because they've shifted the ownership to the charity. I had this question literally yesterday where someone wanted to put some shares of a corporation or an LLC, I can't remember, into a private foundation they controlled, and they basically already worked out the deal. They just don't have it papered. But there's lots of emails back and forth. So the question is that far enough along in the process? And there's concerns that that may be close enough to a definitive agreement. I definitely don't like it once things are signed. The argument is whether the oral agreement could be binding. So that's one that could have a direct impact on charitable giving, maybe in a good way, not necessarily a good impact on people paying taxes if they don't give them the stock or asset away before. There's some changes in the estate and gift tax. I know you've talked about those already, so I'm not going to spend a lot of time on those. And then the last bullet point is, circling around, and I think this always circles around, is dropping the exemption amount down. And this one proposal right now is back down to the 2010 levels, which would be $5 million per individual adjusted for inflation. So those are some big changes to taxes. So I wish I had the ability to tell you what's coming. We have, 2 months, a week. So there's time that things could happen. But Congress is focused on a lot of things right now. The spending bill, the voting rights. And, we're hearing rumors about taxes. We're hearing people talk about them and proposals going back and forth. Some of it's pay-fors, obviously, for the spending that the administration is proposing. That would be some of the increases in taxes. But we don't really know where things are headed. And the concern, rightly or wrongly, is it could be like the 2017 Tax Act where it happens in December. And the question is, how do you plan for something that happens in December that may have some sort of retroactive or impact with very little time to plan around to make a change? But obviously, if the rates are going to increase for charitable giving, this may encourage people to wait until next year because, as I said at the beginning, the higher the rates, the more value you have for the actual contribution. So we will see. Now, the last thing we want to do here today in our time left is talk about some of the traditional planned giving uses or techniques and what you can do in the current environment and how these kind of nuances of where the rates are going to go, interest rates, what are some things that are popular for consideration. Most of these I know you probably already heard of, and you may even be using them with your clients now. But we figured we'd just do a quick review in our remaining minutes on what's out there and what's popular right now in the current environment. Gift annuities, donors that want some source of secured income, like they want to give something away, but they want money coming back. Charitable gift annuities are popular. They're popular in times of economic uncertainty or low interest rates. Then they result favorably to the donor as long as the charitable remains viable. I'm working with a client right now that has quite a few charitable gift annuities from years and years ago that are out of whack with as far as payouts, and they're really costing the charity more money. It's a good thing for the donors currently, that they are getting the income stream, and they're trying to get them to buy out or get rid of them. But for people that are considering making gifts, the effect of the low 75/20 rates, I just looked the other day for November, it's a 1.4% 75/20 rate. For those of you that aren't aware, these are historic lows. This past 2 years in the 1% and below, and now 1.4, very, very low considering where things have been. And so this does reduce the available charitable deduction. So maybe the gift annuity, if you're looking for a high charitable deduction in 2021, a charitable gift annuity is not necessarily the best idea because the calculation of the charitable deduction is based on the 75/20 rate. But in future years, this results in a higher amount that could be excludable from income when you're getting the income stream later on. So the example at the bottom, a 65-year-old with a 4.7% annuity, if the 75/20 rate was 7%, which it has been in times past, the exclusion ratio is only 47%. So if they're receiving funds each year, 47% of that would not be taxable. The remainder is income, gross income. However, at a 1% rate, so not far off from a 1.4, almost 80% of the payments received in the future, you don't pay any tax on. So you get a lower charitable deduction in year one, but a lower amount of income inclusion in later years. Another popular technique for people that want to be charitable is the gift of a remainder interest in personal residence or farm. So you get a deduction in the current year for the value. It's enhanced by the low 75/20 rate because that's used to calculate the value. Here you're giving away something that you might not need, but you still live there. So you live in your house, but upon your death, it's going to go to charity. And it gives you a way to get a charitable deduction now. It also gives you a way to commit to a charity, and you don't have to give up your home. The key thing here for donors and for charities is to negotiate how you're going to operate in the interim. So who's going to make the repairs? Who's going to pay for the repairs? Who's going to cover the insurance? Who's going to pay the taxes? Making sure all that's ironed out up front so the charity knows what its goals are, the donor knows what its responsibilities are, and there's never any confusion. Are you going to make improvements to the house if something breaks? Again, clear agreements make things much simpler in that regard. Another common approach is the charitable remainder trust. This, again, is popular for donors that want to avoid capital gains on appreciated property if they're facing an income event, but it also provides a current income tax deduction without the loss of an income stream. Because remember, with remainder trust, the charity gets the assets left over at the end. So it does have some caution for people with younger donors or charitable remainder annuity trust because of the low 75/20 rates. And you want to make sure you understand how it's set up. But basically, you put property in, and the income beneficiaries initially, whether it's a unit trust or an annuity trust, are going to get a stream of money over a period of time if you're doing a certain period of time for the remainder trust. And then in the end, whatever assets are left are going to go to the charity. We have had over the past couple years people that have longer-term charitable remainder trust that want to tap into them to get money in charity's hands now. Options there, number one, to give up your annuity amount, give up your unit trust amount, go ahead and contribute that to charity, or try to get to the principal for a portion of the gift. And we've seen people do that by agreeing to basically commute or get money in there quickly. Now, more flexibility is needed by some when they come up with these trust structures. So that would be the flip trust, flip charitable remainder unit trust. The key thing here is, what does it mean by flip? Well, the goal here is that at a certain event happening, and we'll talk about what qualifies as a triggering event, you can convert from what's called a net income charitable remainder trust or net income with a makeup charitable remainder unit trust to a straight charitable remainder unit trust. Now, that's a lot of acronyms, and it gets confusing sometimes. What are we talking about? NICRUT, NIMCRUT, I don't know what other people want to call them. But the goal here is that if you have a donor that doesn't need the stream of income that we talked about with a traditional charitable remainder trust, the unit trust or the annuity amount, they don't want the money coming. They really want it to grow with the hopes of getting more money in the hands of the charity. But there's concern that something may happen in the future before the termination of the trust that will result in the payout to the charity, that all of a sudden then maybe they do need some income coming to them. And so when you have this net income charitable remainder unit trust, basically for that one, if there's no net income, there's nothing that has to be paid out. So what would you do here? Well, you'd put in a piece of property or some asset that doesn't generate income or doesn't generate a lot of income, but has some value. So it has some appreciation, or maybe it's going to appreciate. And so next thing you know, that, for now, since there's no net income, there's nothing to pay out to the income beneficiaries, and it grows. But if something happens in the future, this flip or triggering event, then it will change from focusing on if it has net income to actually paying out the unit trust amount. So what are some ideas we have here? Well, unmarketable assets. So let's say, for example, you put in a piece of real estate into this, and the triggering event is some sort of sale. Now the question is, if the trustee can cause the triggering event, then that's not going to be a permitted triggering event. But there may be some other things that you could put in there that they're not under the control of. Retirement planning is another reason to use flip CRUTs. You tie the date to a specific date or event. Again, here you can't tie it to the day I retire, but you could specify a date where you think you're going to retire or something like that. Some donors use this when it comes to estate planning and income objectives. If you're trying to protect a surviving spouse or a child, or planning for educational things for grandchildren, things like that, the goal might be to set it up to where it transitions from a net income to a straight charitable remainder unit trust at those triggering event dates. So that allows for money to be passed out to the income beneficiaries that is, accumulated during the period of time you're not paying it out. So here, there's a lot of creative options and ways to get money both to family and to a charity at the end. But if you're not looking for something that pays out to the charity at the end and you want to get money in the hands of the charity now, a very common technique we're seeing is the Charitable Lead Annuity Trust. Why is this one so common right now? Well, it's common because of the very low Section 7520 rates that we talked about at the beginning at 1.4% for the month of November. And what happens is the lower the rate, it increases the value of the charitable lead interest, which means that there's more money in the computation that's treated as going to charity. And at the end of the day, the difference between a lead and a remainder trust is for the remainder, we said the charity gets the assets at the end. For the charitable lead, the charity is getting the money each year through an annuity payment. And whatever's left over at the end goes to the beneficiaries. We've seen a lot of clients, families with larger income, that are using this as an effective tool to pass money on to their children without paying any transfer taxes at all. That's called the zeroed out 7520 rate, or zeroed out class, where you come up with the payout percentage to be high enough that using the 7520 rate, that the gift at the end under the formula up front says there's going to be nothing left. And then you're just betting on the market. So if the market does better than your payout rate, then you're going to be able to pass money on to your family or children without paying any transfer taxes at all. But again, this is only effective when there is when there's a low 7520 rate. And so people are looking at this as a valid option of something you can do to pass money along. Now, there are options to do an increasing payout and setting it up to where it increases the amount paid to charity over time. That obviously impacts the amount of the charitable deduction and the amount that's supposed to go to the family at the end. So again, these are some traditional ways that we've seen over the years that people are doing in the current environments. With the changes in the tax law, a lot of the increases allowed for the 100% deduction or the 60% in the 17 Act, those really focus a lot on cash gifts to public charities and private operating foundations, not supporting orgs and some of these other factors. So those rules are not really going to impact some of these more favorable things we just talked about. But for people that aren't, looking to give away, significant amount of money in a given year, but still want to do a lot of planning, those are options we've seen that really have a lot of impact and people are interested in. So what we want to do to wrap up is to kind of think about the big picture. So we work with a lot of charities, we work with a lot of donors, and the approach we take with each person or client is going to be different, right? So we don't always go in and focus on tax. Sometimes that's where we think we should start with, but we've learned over the years that's not the best place to start. The best place to start when working with a client on their charitable giving or their desires to come up with options to give back to the community, give money away, is really to think about what are their goals. And so a couple things we do there is we focus on hearing from them first. So we go into the presentation or go into the meeting really in a listening mode and thinking about what is your goal? What is your desire as the donor? What is it you want to accomplish? There are clients that come in and tell us, well, we have no desire to transfer substantial wealth to children. You've seen that in the news. You've seen people talking about, we want to give, set up our family and to be comfortable, but we don't want to transfer substantial wealth. So for those clients, they have obviously a high desire to provide for charitable benefits. Some people focus on, we want to give money now. We don't want to wait till death to transfer money to charity. So again, focusing on what their goals are and what they seek to accomplish. And then that's when we move into, all right, now that we hear what you're trying to accomplish, when, how, the types of charities involved, are there things we can do that are, can be impacted by taxes? Are there ways to do it outside of a traditional tax motive way of giving? We've seen other people look at, younger donors are thinking about things that, are there ways to give money away, but we don't want to be tied into all these 501c3 rules or these charitable rules. The Zuckerberg family is one example where they created an LLC or creating C4 organizations. You don't get the tax deduction, but you have more control and more options with how you give your money away. So those are things people are considering. Again, the goal here is to figure out what really is the driving force. And for a lot of these people, the key thing for them is how can they ensure the good things they want to be accomplished are actually accomplished. And that may mean that you're going to put restricted gifts, which charities struggle with sometimes. That may mean you're going to have different structures in place. So again, the goal is to think about what is it they want. And then finally, when you're looking at younger generations, we talked about other means. You've seen crowdfunding, you've seen GoFundMe, other things that, again, not necessarily going to have tax deductible dollars attached to it, but are ways that people are raising lots of money for good causes. And so people are looking at these as options for philanthropy, because while my goal is to help people save on taxes, my goal is to figure out ways to accomplish their goals and minimize the amount of payment to government. That's not everyone's goals. And so we want to focus on what it is their goal is and how we can reach it. So I leave you with this. Hopefully this was helpful in kind of seeing where things stand from 17 to 2020 to 2021. And now we'll see what the remaining 2.5 months or 2 months and a week and a half now left, whether there's going to be legislation, how it's going to impact, and what we see from Congress. I think from an advisor's perspective, there's lots of possibilities, and there could always be changes based on how they want to get other things passed. So I'm not at the point of saying we must do something before year end. We need to take care of things now. I think a lot of us are focusing on a little bit more of a wait and see. Maybe we'll have better ideas in November or early December about options. But from a charity's perspective, right now they're looking at a lot of things that sound to be positive to get more money out to the general public to help benefit. So I thank you for your time. I'm going to turn it back over to Ben to wrap us up.
Thank you, Brad, and thank you, Stephen and Abby. Thank you to Laura Picker and all those who helped put this seminar together. And thank you for attending. We can't see you, but we trust that you're out there. If you haven't already, you will be receiving an email with instructions about obtaining continuing education credits. Also, since you weren't able to be here in person and ask questions in person, feel free to call any of us. Call me, Abby, Steve, or Brad if you have questions about something you heard today. Hopefully next year we'll be back in person, but until then, we'll adjourn and hope you have a great rest of your day. Thank you.